fact, this is a 3-day series of web lectures. On the first day, our CA advocate Kapil sir will be dealing on section 148. Of course, he will be adding some 148A flavor to that also. And tomorrow will be dealt by Falgun sir with regard to commissioner appeals, and the day after CA Hari sir from Visakhapatnam, who appears in tribunal a lot of the Vizag bench and also elsewhere. He will be dealing on tribunal appeals. So this being the first day, we welcome our chief guest of the day, CA Prasannaji, the speaker of the day, respected advocate CA Kapilji, and also our beloved SIRC past chairperson CA Falgun Kumar, who has helped me in designing the program, and also he has suggested me the speakers who are the best in class of the speakers. With due respect, everybody is knowledgeable. Of course, we have some people who speak at forums. So we are very fortunate to have these 3 persons on our series of web lectures. Now, before we start the session, I request branch in charge Ramesh to play the motto song. We need not stand. As a mark of respect, we may place our hand on our heart. Ramesh, play the motto song. Ramesh? Ramesh, I think you got the wrong one. Ramesh, we need to, okay, right. Share the audio also.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Yes, thank you everyone. Now may I request the chief guest of this day, CA D. Prasanna Kumar sir, Central Council member from our state of Andhra Pradesh, to say a few words.
Respected CA Netta Ravi Kishore, the chairman of the Vijayawada branch of SARC ICA, who is the program coordinator, and CA Jayant Upuluri, the secretary of the branch and also program director, and the immediate past chairman of the branch, CA Narendra, and the stalwart speaker of the day, CA Kapil Goel, and all the participants in the program. So good evening to all of you. So I deem it a great privilege for me to participate and address all of you on this very great occasion of commencing the series of web lectures on a very important topic of post-assessment procedures. More or less, all these are post-assessment procedures, except, the intricacies of reassessment proceedings, with a special emphasis on explanation 2 to section 148. And tomorrow you have got the proceedings before CAT appeals, and thereafter the proceedings before ITAT. This is a very good topic that have been chosen by the Vijayawada branch. I'm sure all these topics are going to add a lot of value to all the participants. And as you are aware, the today's topic, section 148, when I just a student also have seen this section, it's a very simple section, and those days it is sparingly used also. Later on, as and when the judges make their own law, based on the case studies that have been appended with a lot of provisos and also explanation 1, 2, 3, like that, it went on. And today is very much prevalent, and it is settled law that, today it has become one of the main areas of practice to appear before the assessing officer. Maybe this is the only occasion where you go on face to face, sit with the assessing officer when the notice is issued, before they issue final 148 notice, which are again faceless proceedings. So this is a very important one. And, particularly, the lot of controversies arise regarding information which is available with the assessing officer. So, which is the one which suggests whether there's income which is escaped assessment or not, income chargeable tax escaped assessment or not. This entire crux. And I heard our own speaker, Kapil Goel, speak on the same topic long ago, where he was telling he had dissected the entire section, every word, the information, income chargeable to tax, escape, every word has been dissected by him. He explained so thoroughly that a lot of technicalities involved in this one. Based on the lectures and the decisions given by the various courts and people like Kapil Goel, they have been amending the act from time to time. Okay, so such a stalwart person who is going to speak on this topic today, particularly the search and survey, this particular section 140 applicability, the post search and survey application are very, very important. As I told you in a casual talk when I was telling, it was C.A. Falgunu Kumar who used to tell, once we had a meeting, so where he came to me and said, so when I was just listening to Kapil Goel, he said, he is Saraswati Putra. That means Goddess Saraswati got him such a great talent, like that. So when such a person is available today, we are sure that we are going to learn a lot of things. It's going to be great value addition for all the participants. I'm sure being the first day, we are making a very good beginning today. So then tomorrow and day after tomorrow, the other two the second and third lecture also will be of great use to us. And we wish you all the best. I thank C.A. Kapil Goel for accepting our invitation, coming here. And he was telling that his heart is very close to Vijayawada. I'll tell his heart and the hearts of the managing committees of various branches, wherever he goes, the hearts come together. That is the So thank you very much, Kapil Goel, for coming. I thank Vijayawada branch for giving me this little opportunity of talking to all of you. Thank you very much. Wish you all the best. Thank you.
Yeah, thank you, Prasanna sir, for these words. Sir, in fact, Kapil sir, I should tell you, Falgun sir told that Kapil sir is 100 times knowledgeable than me. Sir, Falgun sir, if you can give a curtain raiser for 1 minute to this session, I welcome, and also I welcome special invitee of our Kapil Goel sir, Agarwal sir. You are welcome, sir. I understand you are commuting somewhere. Welcome to Vijayawada virtually, sir. Sir, Falgun sir, if you can unmute and please give a curtain raiser to the session of Kapil Goel sir.
Good evening to all of you. I congratulate the Vijayawada branch for having conceived this 3 days webinar. And as our Central Councilor Prasanna Kumar has said, this is a feast of knowledge going to be shared, and especially from Delhi, our Kapil Goel sir, as I once again repeat that the Saraswati Devi blessed him, or say poured on him the total knowledge in such a way that you are going to listen, and then only this may be my 15th or 16th lecture hearing of the Kapil Goel ji. So wherever possibility is there, I will not miss his lecture. You can understand that how much he is ready to share. So in the month of January, he came to Chennai, and say as he is coming physically, I went to Chennai and sat before him. So that is how this 148, especially the 148 capital A, now the new reopening is giving a lot of say scope for practice. So day in and day out, members are receiving this 148 capital A notices. So the interpretation. See, most of the cases is because of the GST server and the income tax server are being linked. In the if there is a mismatch between the GST and the income tax, and the income tax officer is not able to understand that say there can be difference of turnover. What is turnover for GST may not be turnover. So by assumption, by some say presumption only, these notices are there. 148 ultimately 148 notice is given. Though preliminary inquiry opportunity is given, when they are not able to understand, they will reopen. Once they reopen, what is the basis? So this 148 is such a say big power in the hands of the department, which our learned speaker will definitely enlighten us, and this is so important for us in day-to-day practice. I thank him for sparing this time for our Vijayawada members' sake. Not only Vijayawada, people from many parts of the Andhra Pradesh are there. I am seeing. So with these words, I pray Lord Venkateshwara to give more health to the family, Kapil Goelji and his family members. I wish one day or other in the coming few months, he will visit Tirupati with the family. Thank you, sir.
Yes, thank you very much, sir, for those words. Now, Kapil sir requires no introduction. He is an advocate as well as a chartered accountant. He practices at Delhi High Court, and whatever he believes or speaks in respect of these matters, we should definitely listen to him. Right. Sir, what do you, sir, Kapil sir?
Thank you, Ravi.
Someone is annotating in this. Yes. Sir, what do you, sir, Kapil sir?
So kind of you, Ravi bhai. My warm regards to Kishore Saab, the branch chairman, and our electrifying central council member, Prasanna Saab. I say, see, it is not like that. This is a pure, what you say, submission and sense of my heart. That whenever I see him, he electrifies the atmosphere. And another good friend, and who showers his praise and blessings on me in a very religious man, Dr. Falgun Kumar, and a very erudite man. Though by his love and affection, he definitely, what he says me, I don't know, I deserve that accolade or not, that eulogies or not. But yes, he's Dr. Falgun Kumar has been himself a very learned man and a resource person for the profession. My good friend, and I can say my very good friend, Pradeep Bhai from Kolkata, who has joined me. And there is a reason, Kishorji, during the course of seminar, that why I made him to join this. And I will unravel that during the course of my confabulations, without making it surreptitious and secret. And very senior member, I was just looking at him. He has joined from Visakhapatnam, and a very, what do you say, Kishorji, although many times as I could not go to Visakhapatnam personally, but this Mr. Kama Sastri has been there, and he is one of those what you say, senior people whose blessings have definitely kept my family and me personally and what do you say, boosted up. So as my good friend has already started speaking about my outer personality, but anyhow, so I'm very happy to be here, Vijayawada and this part of the country. I have been there physically also, and the little bit I know and the little Prasanna ji we understand, it's our duty, because this profession has given us and our families everything. It's our duty wherever we can try. Not like you people, you do much more than us. But I'm not comparing it in a relative sense, and I'm saying in humble sense, it is our duty to try to share whatever knowledge we can in the humble manner, treating ourselves as the least knowledgeable man. And I can't, this is my humble submission, Kishorji, that as far as the subject goes and any technician subject goes, Prasannaji, we can't claim that I know very much. When we see daily Supreme Court, Honorable Supreme Court judges and High Court judges learning and just you know, na, there is a word I was looking, learning and unlearning. We have to, this process has to go in an uninterrupted sense, learning and unlearning. And sometimes people say, Kishorji, unlearning is more important than learning. So as Prasanna ji was saying about 148 and Falgun Kumar ji was saying, I can say this is this process of 148 takes us to process of learning and unlearning. So see, as Prasanna Sahab was rightly saying that when he would have become chartered accountant and in his days when he was started practice, then 148 was an exception and rare. Comparing it with the today's time, 148 is now a standard procedure of assessment becoming sort of a standard procedure. It is not no longer a rare or exceptional phenomena, as Pradeep ji is also there and Fagun Kumar ji is there and many other chartered accountants, learned chartered accountant seniors are there. Now, and Falgun Kumar ji was also saying that this has become a very important area of practice of professionals, where we have to daily understand or face ourselves how to respond to this 148 proceedings, which are somewhere maybe one can say that they are giving good amount of professional work, but Kishorji, the quality of 148 is still very much lacking. And the provisions, as the majority of the courts, high courts in the country says, they are abused or they are misused. So the point which I want to start my discussion with is, there are two parts we can take, sir. One part we can have, Prasanna ji, how this law historically evolved itself. Evolution of section 148, I will just give a sequential flow of the law. At one point of time, when Income Tax Act 1922 was there was a section 34, as I can recall, where there was a power given to the Income Tax Authority to reopen the assessment, sir. Now, from 1922 Act, when the reopening power was there in the pre-independence law, there was a catchphrase, Kishorji, it was reasons to believe. Now, our good friends will appreciate the law of section 148 or reopening, as traditionally understood, it was revolving around a phrase, reasons to believe that income has escaped assessments. So now reasons to believe has been the catchphrase. As has been the catchphrase, now suggest word, as Prasanna ji was saying, suggest word. So we have come from the word reasons to believe. Yes, information word was also there in 1922 law and in the earlier 148 law, but the main phrase was reasons to believe that income has escaped assessment, sir. Now, when you try to see the law, how historically it evolved, there has been in the pre-1961 Act and in the 1961 Act, there has been dedicated provisions, sir, Prasanna ji, which has been dealing with this subject of income escaping assessment. Now, why in the law there has been these provisions? I believe 1922 Act it was there, 1961 Act it was there, and even today when we have it is there, it is in a very wider sense. So what is the purpose of the lawmakers or legislature to keep this provision in the Act? It's a remedial provision to the revenue, that where they find some leakage of revenue, they can use it provided jurisdictional criteria of that section is fulfilled. Now, if you see that courts have interpreted this provision in the sense that the reopening itself, what you say, disturbs the finality of an assessment. So it has to be viewed strictly, though it is a procedural provision, machinery provision, but it has to be given strict interpretation, sir, because it disturbs the finality of a concluded or a already completed assessment. Now, there are two ways to look at it. One is that Income Tax Act 1961, Income Tax Act 1922 have been containing the provisions which dealt with the income escaping assessment, but there has been different tenor. In 1922 Act, there was one set of provisions which dealt with this income escaping assessment. When we came in 1961, in 147 section, there has been another, when 1961 Act was made, then also Section 147, which was there and which has been there till 1989, it had the provision of income escaping assessment. The major emphasis was reason to believe. And from 1989 to 2021, now major overhaul when this latest law was substituted was done in 2021. Before 2021, the law which was there, it was last amended in 1989. So all these things I am just saying to give this idea that pre-2021, when the current law 148 is there, which is going to be discussed, there has been a phrase which has been very seriously debated and analyzed by various courts, by in reasons to believe sense. Now, this reason to believe is very familiar to various people who are dealing with income tax practice. So, reason to believe was analyzed in one of the important decisions by Supreme Court in Lakshmani Mevaldas 103 ITR 437, that reason to believe is not equal to reason to suspect. Reason to believe cannot be mere pretense, and reason to believe has to be based on tangible material. These are the three tests. Reason to believe cannot be reason to suspect. Reason to believe cannot be mere pretense, and reason to believe has to be based on tangible material having rational connection with the case of the assessee. Now, this test was propounded by Honorable Apex Court in the leading case of Lakshmani Mevaldas 103 ITR page number 437 by Justice H.R. Khanna, which judicial pronouncement, in my humble opinion, Falgun Kumarji, should and is held to be would apply in the new law also. Although revenue authorities are not appreciating this argument, and there is still a sense of discomfort in the department that they don't want to apply the rulings which have been the balanced objective rulings of the Supreme Court in the pre-2021 law to the new law. But in my respectful submission, those rulings should hold the field in the new law also. And I will tell you why, just when we will start discussing the new law provisions. So I was just giving a historical background, Pratibhai, that before, all of 2021, before there was a set of provisions, and now we have a different set of provisions. The change is the word reason to believe, which was there in pre-2021 law, has been substituted with the new word information suggesting escapement of income. Now, this word is the new word which has to be analyzed before it is to be seen whether 148 is rightly taken or wrongly taken. So somebody has been, as Falgun Kumarji was saying, that now when you go to reply to 148, it is an information driven section. And there is a very important change of technology here also, Falgun Kumarji, that now this 148s which are done in current regime, they are done by this technology oriented 148. When the this information comes on Insight portal of the Income Tax Department, that Insight portal information is used to do 148. So this is not the time when the information is coming in all information are coming in physical hard copy. This is a era when reopening is done on the information coming on the Insight portal, and that Insight portal information is further subsequently developed and used to reopen the cases in the new regime. So I will use in my discussion these two words, old regime and new regime. Old regime, when I say this is prior to 1/4/2021, and new regime when I say it is after 1st April 2021. Why I am taking 1st April 2021? That is the cutoff landmark date, epochal date when the new law of 148 was substituted by the parliament in place of the earlier law. Now, before reading any law, it is being advised by our sage advisors that you have to understand the mischief, Pradeep bhai, what is the purpose of this law? Why 2021 new 148 law came? Why parliament felt that earlier 148 law has to be replaced and substituted? The word substitution has been done. Why new law has to be substituted of 147? The reason which is given in the finance bill memorandum explaining 2021 by the legislature is that they want to have the new law of 148 to reduce litigation, to have lesser number of cases being reopened, and to have ease of doing business. These are the three mantras: ease of doing business, lesser number of cases, and less litigation. And somebody can rightly say whether all these three things is happening in the new law. One can self-analyze this, sir. Whether this is happening, that lesser number of cases are being taken, less litigation, and ease of doing business. So these were the three goal posts due to which this game changer provisions were introduced, like Section 148 capital A. And that's why this entire chain of new 148 provisions are there. But somehow in the just to reopen cases, it has been observed practically by us when we go in high courts and when we fight these cases, that the objective which was there behind this new law substitution has been lost somewhere. Although objective was very laudable, but the implementation has been somewhere by the revenue authorities, which is opposing or what you say counterproductive to the objective of the lawmaker. Now, when we have seen why the law has been substituted, and when we have briefly understood the prior 2021 regime and post 2021 regime, it is important to understand the step-by-step exercise, Pradeep Bhai. Now, I was just noting down that in the new law, Falgun Kumarji, 148 has to take place. Then what is the step-by-step exercise? First, you have to understand what are the important provisions in this. Then you have to develop a step-by-step exercise. Now, important provisions in this new law is, before coming to the new law, I just want to underline one very important thing or judgment. All my good friends know, or if they are not aware, they can note a Supreme Court ruling. There has been a Supreme Court landmark order in the naming the case of GK and Drive Shaft. GK and Drive Shaft citation is 259 ITR, page number 19. Why this ruling has been very important in pre-2021 law? This ruling said that in the prior to old regime law, when reopening was taking place and reasons were recorded, then 4-step exercise will be followed. GK and Drive Shaft, you have to note down 4-step exercise. Then you can compare the new law step-by-step exercise. The old law, this epochal Supreme Court ruling, GK and Drive Shaft, 259 ITR, page number 19, laid down the law by Supreme Court dictum was, that when reasons are recorded and case is reopened under the old law, then when first assessee will file the return. You know, written means written in pursuance to notice under 148. Then you can ask Pradeep Bhai reasons to believe. Assessing officer will give you reasons to believe. You can file objections. Objection means challenging the reasons to believe that they are not correct. They do not give rise to believe, they are not proper, valid, etc. First is written filing under 148. Second is reasons to believe taking. Third is objection filing. And fourth is objection disposal. Now, this 4-step exercise was not there in the statute. It was there under a Supreme Court ruling naming GK and Drive Shaft, I am again submitting, which says that when reopening was done under old law, these 4 steps have to be scrupulously and very strictly fulfilled. First, assessee will file the ITR under 148 section. Then reasons recorded will be supplied to the assessee by the tax authority. Then assessee can file objections challenging the assumption of jurisdiction under 148 that reasons to believe are wrong or invalid. Then objection, Kumarji, will be disposed. And then subsequent final assessment, subsequent assessment will go. Now, this process was judicial, judge-made law. It was not part of the section 148 old law. One of the important things which has been done in the new law is that they have incorporated the cycle. I say GK and Drive Shaft is a cycle and process. GK and cycle has been introduced in section 148A, Pradeep. Now, GK and cycle, when I say GK and cycle is introduced in the Income Tax Act in the new law of reopening, that is section 148 capital A. Now, note down, Kumarji, what is the 4-step exercise in the 148A new law. 148 capital A section, which was brought by Finance Act 2021, it says that before a case is reopened under 148, what will be done? There are 4 steps suggested in section 148A. One is prior inquiry may be done if required. If required, prior inquiry may be done prior to show cause notice. Second is show cause notice under 148 capital A clause B. Now, people who are doing this 148, they have seen, I will just come to what is the quality of these show cause notices which are issued under 148A, which are many times mechanically issued, and one cannot make any sense out of it that what is the charge against the assessee. Anyhow, 148 capital A has 4 steps. First, prior inquiry clause A, clause B, show cause notice to the assessee, clause C, consideration of reply filed by the assessee, clause C of 148 capital A, clause D, passing of order whether it is a fit case or not. Now, my friends can appreciate this GK and drive shaft, which was judge-made law, has been introduced into the Income Tax Act 1961 by Finance Act 2021 in the shape of Section 148 capital A. Now, 148A gives statutory recognition, Prasanna ji, to the GK and drive shaft. Now, why it is to be noted down? Somebody can, Falgun Kumar ji can join me, or just to make this interactive, that the purpose of GK and drive shaft to bring in the Income Tax Act was this, sir, that before a case is being reopened, there is a sorting that whether it is a deserving case to be taken for 148 and whether it is a non-deserving case. Therefore, lawmaker have introduced this game changer and a great provision like 148A, saying that before a case is formally reopened, you have to check whether it is fit or not. Now, the way this 148A exercise is being done, Prasanna ji, and the interpretation of 148 capital A of 4 steps is the subject matter and bone of contention between SSC and revenue. And rightly said, our like lawyers who are appearing in high courts, sir, and courts, our main bread and butter is going due to 148A. I have no hesitation to say on lighter side. Kishorji, our bread and butter is propelled by this 148A. If you ask me, Mr. Goel, how many cases in your professional chamber you are doing of 148 and other non-other, I will tell you my 90% cases are of 148. And the point, Kishorji, the point is this paradox, that majority, I will say humbly, Prasanna ji, at a time, I felt when this section was introduced, when we were called to speak, that how Mr. Goel, this 148A should be, Kishorji. I said that this should be a game changer provision. Now 148 should be done in very lesser number of cases. Because if you are doing 148A, this GK and drive shaft exercise prior to reopening, then definitely all those non-deserving cases should be, weeded out and flushed. But sir, the experience has been totally different now. This 148A drill or 148 capital A cycle and process has somewhere become a, ritual and formality. And I have no hesitation to say so. And it is based on my experience across country when I appear in high courts and when I speak, that 148A has been made a, sometimes a very laughable situation is created. That when
naam ke vaste section.
Sorry?
नाम के वास्ते सेक्शन.
राइट बिल्कुल नाम के वास्ते सर, नाम के वास्ते बिल्कुल. अब सोचिए नाम का वास्ता है, अभी इतना बड़ा सेक्शन बनाया है, उतना इंपॉर्टेंट सेक्शन बनाया है, इतना, this kind of section is very important. Whoever made it, he deserves 100 and 1000 accolades. But the way it is being implemented by our great revenue friends, I'm saying like this, it is becoming a, I don't know what I should use, Prasanna ji. This 148A has become rather, boon or bane? Pradeep ji, it is a bane or boon? Agarwal sahab, 148 capital A is a boon or it is a bane?
In the due course, it will become a boon, sir. Now it is a bane, but in the due course of law.
Kumarji, it is your beauty. See, it is your, value of the beauty lies in the eyes of beholder. So you are a great man. You are looking at it like this. I'm telling you, I will just bear with me. I will try to submit where from I am coming. That when department going ASD, going before Honorable High Court, none other than Venkatraman Saab, and saying to Karnataka High Court, you note down the citation and you read what Mr. Venkatraman said to Karnataka High Court in 470 ITR, 470 ITR in this case of Vasanti Ramdas Pai. What is the government stand, ASD stand? 470 ITR 536. Kishorji, 470 ITR 536 is the decision of Honorable Karnataka High Court in Vasanti Ramdas Pai, authored by Justice Krishna Dikshit, where ASG Mr. N. Venkatraman was assisting the from government side. Now, in the new, it's a epochal order, not because it is a SSC favoring order, because I'm saying, because it thrashes that whether while coming from the old law to new law, is this a law that giving arbitrary and unreasonable power, that it is totally dependent on whims and fancies of the officer? Argument was given from ASG and government side that this new law can be used without any reason, which has been taken on head on by the High Court, that if you say that any reopening law can be used without any reason, then it will become unconstitutional. But my question is different to Fagun Kumarji. Can the government and the person who is representing the government say and argue against what was their legislative intent? Is it a joke that you reopen the people's cases and then go to court of law and say that we are not supposed to give any reason to anybody. We are not accountable and answerable to anybody. Then for what the memorandum said, it is for lesser number of cases and less litigation and this all these things. God bless these judges of high courts which have taken on board this argument and rejected it. And now you see, Kishorji, in every high court or court, wherever this litigation is taking place on 148A, especially writ courts, the department standard argument is this, sir, since we have dispensed argument or this requirement of reason to believe, and since we have come to information-based law, there is nothing to be seen. Only it is totally dependent on whims and arbitrary caprice of the AO. How many dozen cases? And see now why I am saying like this is Falgun Kumarji, various high court judges also now some are taking favorable view to the SECI. Now, there are some high courts, you can note down Allahabad High Court and Madhya Pradesh High Court. I am giving you the citation where Allahabad High Court has accepted this argument of revenue. Kishorji, few high courts in the country, honorable high courts has said, yes, department is right. Now 148, after reason to believe what has gone away, it is totally the discretion, arbitrary and unbridled discretion given to the revenue to use 148 in any manner. But the question which I ask my learned audience is it the legislative intent? Is it the legislative purpose? Is it the legislative mischief? Is it the way you will give ease of doing business? Is it the way you are going to have lesser number of cases? Is it the way you will have a finality to the proceedings? And if this is going, see, Kapil Goel like lawyer flourishing. We are professionally talking, we are sensible, intellectual people. But is it my own mother's case, has been reopened on totally arbitrary ground, Kishorji? My mother has shown everything in her return of income. Kama Shastriji is there. Now, Kama Shastriji, my mother, a senior lady, has filed her return and shown all transactions. Now, 148-day show cause came. My younger brother Sandeep ji gone to income tax department to explain to the concerned ITO, great ITO, sir, our mother's ITR captures every transaction which you have picked up from arbitrarily from this annual information. He says, Kishorji, yes, you are right. Your mother has accounted everything. But this will be not checked by me in 148 these days. This will be checked in subsequent assessment. Arey Baba, then why you are doing 148 Is it for fun? Is it for joke? Is it for entertainment of somebody? And what is this sanction business? Chief Commissioner will give sanction after 3 years and Commissioner will give within 3 years. Is it the way you will make reopening a sensible exercise in the process known to law? You see, that's why I was saying to Falgun Kumarji, when this provision came, we were all very happy that 148 will now be used in lesser cases and fit cases. But the way Kama Shastriji, this has been interpreted and applied by the government, these revenue authorities, it is going above my head many times. And when I see this argument coming from highest judicial officers of the government, that now, Kishorji, you know the gravity of this argument, that saying that the reason to believe has gone, so reopening can be done in any and every case, wherever AO feels so, and wherever any scribble information comes is 148 done. This is 148. Then our institute should represent also. Prasanna ji is there. You see, if you interpret 148 in the manner in which it is being suggested by revenue authorities, that it is total depending upon whims and fancies and arbitrary discretion of the AO, then entire purpose of new law goes haywire. And see, that's why I was telling Allahabad High Court, which has taken in again. And this, Kama Shastriji will appreciate that department friends always sees these rulings which are against the SECI, where this extreme view is taken, Kishorji. And I'm not telling it for any other purpose. I am telling it in a scholastic sense, academic sense, humble sense. That Prasanna ji, the two rulings I am just citing, which are against SSC and which have taken on board, which have accepted revenue's argument that new 148 law can be used in any manner in which revenue wants. One is 460 ITR 50, 460 ITR, page number 50, Allahabad High Court, Deepak Kumar Yadav. And second is Madhya Pradesh High Court, Amrit Holmes, 457 ITR 334. Madhya Pradesh High Court, Amrit Holmes, 457 ITR, page number 334. And latestly also one Allahabad High Court order has come, Prasanna ji, where the Allahabad High Court was to answer an issue on 148, a new law, that some search took place, Kama Shastriji, on a real estate builder. Real estate builder happened to have found some, documents suggesting that people who have bought flats and land have given extra money. Now that document were trustworthy. I'm saying in summary sense. And arbitrary case have been reopened of various buyers, bona fide buyers who have bought properties, Kishorji, from that particular developers. Search took place on a developer. Case is reopened under the new law. Consequent to that search on the buyers, and the basis which is being given is some loose and unsubstantiated and documents which has no sense. Now, the point which Honorable Allahabad High Court, to my humble opinion, has gone wrong totally is in this April 2024 decision, which I say as a student of law, with all due respect to Lordships of Allahabad High Court, this is the case of Ravinder Pratap Shahi. One can note, Kama Shastriji, Ravinder Pratap Shahi versus Union of India, 9th April 2024, it is the decision. Ravinder Pratap Shahi versus Union of India. Ravinder Pratap Shahi versus Union of India, Allahabad High Court, 9th April 2024. Yes, Velubulaji, just let me complete 148 first. I will then stay, etc. I will come later on. Please don't defocus me, with due respect, sir. Bear with me. I will lose my chain. So, Ravinder Pratap Shahi versus Union of India, I was saying, sir, Allahabad High Court 9th April order. Raviji, this order, I am not discussing just to say that it is negative order, adverse order. I am just trying to bring my point home that what Allahabad High Court said in rejecting writ petition of assessee, that anywhere and everywhere 148 is done in the new law, assessing officer cannot be asked that what is the justification of the same. Is it a, what is this? Is it a law? Article 14 of Indian Constitution says what? Can you reopen my assessment on ipse dixit? And then justify it in future we will be better off. And someday we will be better off. Today I am worse off and future I am better off. Sorry, sir, I can't have this kind of, I lack the comprehension to explicate myself with this kind of thoughts. Then you are, see, the problem here is, Kishorji, reopening business is a serious business. Reopening business is not a business of joke. Reopening business cannot be made contingent that future department may do. So now you know what is happening, Kama Shastriji, you will appreciate. Prasannaji, you should also understand this interesting situation. See, many people were very happy. Fagun Kumarji, many people were very happy like me. That now new law in 148 says after 3 years reopening will be done. What is the monetary threshold? Amount is 50 lakhs, right? 50 lakhs. Now, it was, see, earlier there was when this 149 section was there, sir, and when reopening Kishorji was done after 4 years, the threshold was 1 lakh. Please note historically, Kama Shastriji will appreciate, when before 2021, the law was their old law, and case was reopened after the end of 4 assessment years, the monetary threshold was 1 lakh. Now it is being taken 50 times up. And that too when the case is reopened after end of 3 years. Am I there? Now, Kishorji, appreciate, Kama Shastriji, all of you, that there is a case study like this, and it has happened in various places. To my shock, I went to Jaipur, Rajasthan, various other places of CA Institute. Wherever I find this case study, I got. What is the case study? That information came to the learned assessing officer of Income Tax Department from a source that Kapil Goel has got this amount of capital gain, which is bogus capital gain. Okay. Now, the same information, Kama Shastriji, on the same subject matter comes to the same officer from a different source also. I have done only one transaction. Let us say it is 30 lakh rupees. But this information comes from two roads. So it becomes 30 into 2. How much? 60 lakhs. Sir. ऐसे नहीं है Ravi ji. See, assessing authority without applying the mind, the great, see, they believe they are insulated from the duty to apply. Mind is taken away from them under the new law. That is their presumption. So they say that Kapil Goel has not done 130 lakh transaction. Kapil Goel has done 230 lakh transactions. Kapil Goel, like beating the wall with the beating the head with the wall. Sorry. tried to explain to the officer, ki, sir, I have done only one transaction. This is my bank account. This is the only transaction. Kama Sastriji. Still assessing officer reopened my case with 60 lakh amount. And case is reopened beyond 3 years. Now, climax of the film has not come. Climax will come now. When the faceless assessment officer comes
Sir,
into the picture.
in land development, where the landowner also signs all the documents, the landowner flats as well as the developer flats, all flats come and sit in the landowner 26 years.
Yes. Then, but then
So,
they reopen.
notice is given for all the flats, and this fellow, the onus of the proof is on the SSE to prove that the other documents are of the landowner, the developer.
Keep this point. This is a very important point which you said. This great burden, we are in a civilized law constitution driven country, that negative can be asked to be proved. God can prove Banke Bihar. I say, sorry, Prasanna ji, can Lord Venkateshwara prove negative? Yes. But as a human being, I can't. Can you ask taxpayer to prove negative? Fagun Kumar ji, God forbids. Can you prove negative? This inhuman talk. First
No,
you
ji.
show you are innocent, then we will prove you. See, are you doing 148 or am I saying you come and do my 148? Kamal hai, sir. Abhi suniye, abhi Kishore ji, kindly loud. This 30 lakh becoming 60 lakh. And appreciate, this is beyond 3 years. Otherwise, the case is below 50 lakh. Prasanna ji case should not have been reopened. Now, assessee, when he faces there are two phases in the reopening. One is 148-day exercise and one is Kishore ji after 148-day. That is assessment. Now, in assessment, when I appear before faceless officer, we have our challenges, all of us know. Assessee says to the assessing officer the same song, faceless assessing officer. There was Jao, here it is Fao. You know, Jao means jurisdictional assessing officer and Fao is faceless assessing officer. Now, before Fao assessee says, these acronyms I have not made, my good friends have told me. This Fao sub assessee tells the same prayer. Sir, I have done 30 lakh transactions, sir. Sir, my case is beyond 3 years, sir. Sir, my jurisdictional threshold is not fulfilled under 149 subsection 1, sir. Kindly drop my proceedings, sir. What is the answer, Kishore ji, he gets from the Fao? He says, once your case is reopened, means for all ages and times it is reopened. It is locked for all times, irrespective whether how erroneous it was. Can Prasanna ji, this understanding be justified? And for this, assessees have to go to high courts, hire engaged lawyer like Kapil Goel, pay professional fees to lawyer like Kapil Goel. I'm saying to myself, and then get the justice. This is the beauty of the system. One can has a very beautiful sense of this system, that you have to get 2 plus 2 is equal to 4. Then you have to go to every case to go to high court, and every case has to go to writ petition. Every case has to go to my lords, and every case has to be shown that, sir, I deserve justice. Please give me justice. You know why, Kishore ji, I told this? See, it looks very plain that if a case is being reopened after 3 years and amount of the income escaping assessment is less than 50 lakh rupees, then the reopening cannot done. But due to the duplication of figure, duplication of multiplication, you are noting this point. And which is the error done by whom? Assessee.
Reporting entity.
Yes, and reopening is done by whom, sir?
Yes,
So it is the error of AON. What mind, great mind has been applied by commissioner and chief commissioner, the highest officers. And you know, when this objection was taken before Fao, this is not dropped. Addition was made of lesser amount, 30 lakhs. And reopening was started with how much amount? 60 lakhs. And they downscaled it to, is it right? Not the reopening should have been terminated at 0 and return income should have been accepted in this case study. Justice Arun Bansali, my good friends, can note one decision of 2024 on this point. Rajasthan High Court, and this vindicates, Prasanna ji, my statement. Everything which I have said can be found from this order of Honorable Rajasthan High Court by a very senior judge. He is now the Chief Justice of Allahabad High Court. by Justice Arun Bansali Saab. The name of the case is Bijender Singh. Bijender Singh versus Income Tax Officer, 4th January 2024. Kishorji, the name of the case is Rajasthan High Court, Bijender Singh versus Income Tax Officer, 4 January 2024 by My Lords of Rajasthan High Court, Justice Arun Bansali. He says कि if at the later stage it is also found that amount of the income escaping assessment, correct amount and actual amount is less than 50 lakh and erroneously it was started with more than 50 lakh, then proceedings should have been closed at 0, addition 0. But department is not able to even accept this point. I am not criticizing for sake of criticizing, or it is not even criticism, it is a feedback, humble. That if you are making a new law for the welfare, salus populi suprema lex. What is this Latin maxim? I have a very bad habit of quoting Latin maxim. Salus populi suprema lex. It says welfare of the people is the supreme law. Salus populi suprema lex. Is it applied? So Kishorji, I was saying that this Prasanna ji, even this basic point is not clear in the revenue mind, that when we have come from the law which was having the word reason to believe, and when we are in the law information suggesting escapement of income, whether all checks and balances are blown or whether 148 is now the arbitrary baby of AO, and whether there is any sensible sense which has to prevail on the AO before doing 148 in the new law. And I can tell you 12 decisions. I told you Allahabad High Court and Madras High Court towing the negative, adverse tone. Now, kindly note down a series of judgments. This may help all of you. I have just jotted down that even when we have come from the new law, old law to the new law, the requirement of the law to use 148 can be done only if, Kishorji, there is the, threshold requirement of income escaping assessment being fulfilled. And there is tangible material to the AO. Lakshmani Mevaldas still applies. I have 5-6 decisions to tell you. One is Odisha High Court in Biju Janata Dal. Biju Janata Dal is a big political party of Odisha. Odisha High Court in the case of Biju Janata Dal has held that when new law 148 has come, it does not give arbitrary power to the AO to use any and every information for 148 in the case of Biju Janata Dal. Then Honorable Madras High Court, Dr. Justice Anita Sumant ma'am, a very tax eagle. I have highest respect for her. Honorable Madras High Court, speaking through ladyship, Justice Anita Suman, Dr. Anita Suman, Falgun Kumarji, in 2 decisions. Madras is your jurisdiction, Falgun Kumarji, although your jurisdiction is entire India, but this Madras, please note it down. 2 decisions of Madras High Court, one in 459 ITR 166 and 459 ITR 568. There are 2 decisions of Honorable Madras High Court, Kishorji, 459 ITR 568 and 459 ITR 166, where Honorable Madras High Court, the name of the two cases is, one is IDFC Limited and one is Dr. Matthew Charian. Dr. Matthew Charian is one name of Madras High Court case and second is IDFC Limited, sir. In both these cases, Madras High Court has taken this point whether while coming from the old law to new law, AO is denuded and immunity from its duty to apply mind and to use 148 in arbitrary manner. Madras High Court says no. Odisha High Court says no. Madras High Court says no. And Madras High Court 2 decision name, I repeat, one is Matthew Charian and second is IDFC Limited, sir. Third is the decision of Honorable Rajasthan High Court, latest decision in RK Build Infra World. RK Build Infra case. This is latest citation. 462 ITR 478. 462 ITR 478, Rajasthan High Court, RK Build Infra. 462 ITR 478. That when we have come from old law to new law, AO is still required to apply his mind whether information is worthy to use and for doing 148. Then this, I told this decision of Kishorji, this landmark decision of Karnataka High Court in Vasanti Ramdas Pai. This is a landmark order, I'm telling you. Everybody should use 140 while doing 148, Prasanna ji. Ramdas Pai. This is a Manipal case, family case. By Vasanti Ramdas Pai. Judge, author is Justice Krishna Dikshit. The citation is 470 ITR 536. 470 ITR, page number 536. Where Venkatraman Saab appeared and where all departments' arguments are rejected. And what is the preposition given, Prasanna ji, in this case of Vasanti Ramdas Pai? I, Kapil, Goel, Kishorji file ITR. Now, Kishorji, tell me, open your mic, that what is the length of the ITR and what are the amount of disclosures you are supposed to make in the ITR?
More than 50 to 60 pages.
Okay. Now, it is whose prerogative, Prasanna ji, to do 143 subsection 2 scrutiny? Is it assessee's call or it is a department's call?
Department.
If you have disclosed that you have sold a property and it is less than stamp value rate, you are not supposed to pay capital gain always at circle rate. Then you disclosed it in the ITR. For some reason, scrutiny 143.2 did not come. Can department on the same information, which is already forming part of ITR, do 148 in the new law and say that the information which is available in the ITR is the information suggesting escapement of income? I repeat, can revenue use new 148 law saying that what is the information which was already available with the ITR is being used as the information under the new 148 law suggesting escapement of income? Is it permissible? And when 143.2 bus has been missed, Karnataka High Court in this 80-70 page order says no. If department is being allowed this free hand in 148, then entire scheme of law will get upside down. So Kishorji, one has to appreciate that what understanding Honorable Allahabad High Court and MP High Court gave to this 148, to my respectful submission, it is wrong. Rather, Karnataka High Court, Madras High Court, Odisha High Court, Rajasthan High Court, and now you can also note this this Delhi High Court latest order 463 Suridhi Commercial. Delhi High Court latest order Suridhi Commercial 463 ITR 169. 463 ITR 169. Now, all these decisions combined together says that in the new law also 148, revenue is to justify that what is the actionable material. And most importantly, all of this is the stand taken by Bombay High Court, Kishorji. Maximum favorable cases on new 148 are coming from Honorable Bombay High Court. One is the case which you can refer is the Karan Maheshwari. Karan Maheshwari is the latest order of Honorable Bombay High Court, where the allegation was this, that assessee is part of some scam. And reopening under new law was made, Prasanna ji. But Bombay High Court quashed the proceeding, writing a detailed order saying that the old law of Lakmani Mehbal Das will apply, hold good in the new law also. So all these things which I submitted, that there is a serious debate going on between the department and the assessee, that whether in the new law revenue can do anything. Let me test my point from another angle. This is one thing I completed. Kishorji, when revenue gives scrutiny notice to assessee and 143.3 assessment is done under regular assessment, and I say it is an Agni Pariksha. 143.3 is not a simple Pariksha. One is our CA Pariksha. Hey, Prasanna ji smiles. So this is a different Pariksha. I say people I am not an assessment going man, but all commiserations are there to the assessees and councils who handles assessment, sir. It's not an easy thing. To handle income tax assessment, that too in the faceless assessment, and that too to make another person understand everything through writing is a task which only I don't know how it is done. You know, here I recall one thing, Kishorji, Prasanna ji. The same Allahabad High Court has written a landmark order. Although I can't, I will discuss it, but this is an epochal order on a positive note. This is 2 days back, Allahabad High Court has written this order. You can know, all of you can note Satish Kumar Bansal. This is Satish Kumar Bansal, sir. Satish Kumar Bansal. This is and this is from Allahabad High Court, and this is on the issue of what is the importance of having oral hearing in the faceless assessments, and why it is and how it is challenging for assessees to just communicate through written replies, and why it is important. Kishorji, this judgment is a epochal order 2 days, 3 days back. That where they have said that wherever income tax department has made additions to the written income and assessee has replied to the show cause notices that addition should not be made, oral hearing is a compulsion, even though assessee has not specifically requested. I repeat, what is the preposition given by Allahabad High Court in this another level of preposition, that if you are facing a faceless assessment in income tax law and you are given a show cause notice for variation in the written income, and assessee replies to it but somehow does not ask for oral hearing. And now you will say, ki Mr. Goel assessee does not ask, then why department will give? But lot of additions are made, and assessee has objected to the additions and contested the additions. Now Allahabad High Court says in this 2 days back order interpreting 144 capital B section, subsection 6 of faceless hearing, that wherever there is a variation to the written income and assessee has objected to the variations, then Kishorji, if oral hearing is not granted, even though not asked, then it is assessment is bad. Are you noting this judgment, Satish Kumar Bansal's case? This judgment contains 2-3 very important paragraph and loving paragraph, I will say. Jaise hota na, if there is a caption in the message is loving. If there is a 2-3 paragraph, what it is saying that it is capturing first time these points that when you are attending any proceeding in e-proceeding in faceless manner, what are the challenges and limitations of written replies? Allahabad High Court has taken pains in this particular Satish Kumar Bansal's case, saying that when a taxpayer is participating in income tax assessment through faceless mode, then it is really challenging and it has limitations to tell everything through written replies. Department should endeavor in ordinary, in all cases where variations made, oral hearing should be given, provided from department own side. Now tell me, Kishorji, whether this culture, which Allahabad High Court has just said, this is a landmark order, just tell me how much practical things differ from this.
Sorry, in video conferencing, some chartered accountants have opted for video conferencing, sir. The respected assessing officer will hear everything, appears to be satisfied with everything, make the addition and pass the order.
But this is a joke.
Sometimes, when we discuss with my friends, it sometimes happens.
But I am telling you, sir, that there are 2-tier hesitations here. One is to give oral hearing properly. Just for example, in 148 stage, we generally don't get oral hearing, although there also department is supposed to give us oral hearing, you know. Kerala High Court has said in 148 capital A stage also oral hearing is required, if specifically when it is asked.
And
Just
one more dimension, sorry to interrupt you, sir.
Please.
For objections to show cause notice, along with that, within 1 month, application with the dispute resolution panel is to be filed, and proof of filing that has to be, acknowledgement has to be submitted to the assessing officer within 1 month. If that is not done, immediately after the expiry of that 1 month, for the lack of this acknowledgement with the DRP, the order will be passed with the additions which have been suggested in the
draft order becomes final order. See, therefore, there has to be what is this sense of I just digressed. I will just rejoin my point, Kama Sastriji, that in 148 stage, revenue has been treating this as a formality and a ritual. Whether, in my humble opinion, this is a very serious drill. This is a serious exercise. This requires serious application of mind. This requires full attention to the consideration. And now various cases, Kishorji, are there. If you are given a show cause notice, as a typical chartered accountant and a person who prepares reply like Kama Sastriji is there, he's a great hard worker. He will file everything. All objections he can take under his belt, he will take his good self. Now revenue officer says, no, I will not deal with all these objections at preliminary stage of 148A. This will be taken care of in the subsequent faceless assessment stage. This is also a serious mockery of the 148A. See, read section 148A. It says consideration of reply filed by the assessee. What is the meaning of what consideration? What is the quality of consideration? What is the quality of application of mind? Whether your all objections are disposed of with full attention. There have been the cases where assessees, all 148A C reply have been put to trash and the orders are passed. See, Falgun Kumar, you start saying that I have information. You end with saying I have information. But where my reply goes? I have said you are wrong. You say I will not consider I am wrong here. Other officer will consider in future. Is it the scheme of the act? Is it the way you are giving less number of cases and lesser litigation and ease of doing business? Is it the way 148A will give SOCOR and replace GK and drive shaft? I asked Falgun Kumarji in my academic sense to my younger brother, kindly note my point, you will appreciate, you are a very learned man. Whether in new law you have gone down from GK and drive shaft, Kama Sastriji, to lower level, or you have gone up. I repeat what I said, and very important question I am raising to the house, that in the new 148 law, whether assessees law has gone below GK and drive shaft or it has gone above GK and drive shaft. Tell me, sir, tell me.
Intention is to upgrade, practically good.
Yeah, I'm very happy to note this word intention. Kindly complete your sentence. Kindly complete your sentence.
Yes, sir. So
Intention is to upgrade,
but practically the officers are not able to understand the spirit.
Sir, in this ladai, in this jhagda, in this struggle, in this entire, what do you say, tug of war, entire, Falgun Kumar ji, now this has become a state-specific law 148. In some states, the high courts are blissfully favorable. Now let me talk about Telangana High Court. I am in Telangana, it's a Telangana Andhra Pradesh jurisdiction.
Andhra Pradesh.
They both are different, sir. Both have different high courts.
Hi, yes, both have different high courts, but your members are from Telangana, Andhra Pradesh, and there's Kama Sastri ji, Visakhapatnam.
Andhra Pradesh.
Andhra Pradesh.
And Telangana?
Hyderabad.
Okay, I'm telling you, but now they have been separated high courts after the division of the state. Kama Sastri ji, Justice P. Sam Koshi, he was earlier Chhattisgarh High Court judge. He came in Telangana High Court. I'm making you, all of you, note down what is the great approach of this man. I'm fond fan of him, sir. I've not met him, but I've tried to read his all judgments in income tax when he has headed the bench in Telangana High Court. Now, what he has said in this one of the order which I was reading, Kishorji, you must note, all of you. This is the order of Telangana High Court. I have just got it. It is the name of Zareen Saeed. Zareen Saeed. Z-A-R-E-E-N. Zareen Saeed. Writ petition number 2104. Zareen Saeed. Saeed. S-Y-E-D. Zareen Saeed. 2104 writ petition number 21054. Public 2022. The issue was this before Telangana High Court, Justice P. Sham Koshi, Division Bench. Kama Shastriji, it was an income tax assessment. And there was some back material gathered by the revenue, and they generally, Prasannaji, gather a lot of information against us. And they have, the department's culture is to not give the information completely or selectively provide. Now, this was one case, Kishorji, where Telangana High Court assesses complaint to challenge the income tax assessment and reopening was, sir, at the reopening and at the final assessment, they have used a report of register valuer report something against me, and they have not provided the copy and confronted to me. Telangana High Court Division Bench has applied Supreme Court another landmark order by Dr. D.Y. Chandrachud in case of T. Tekanu, note it down, saying that T. Tekanu, it's a SEBI law judgment, used by Telangana High Court in income tax case, T. Tekanu, saying that Falgun Kumarji, if income tax assessment makes an assessment on basis of a material which is not confronted to the SEBI, then entire assessment will be invalidated. Why I'm saying it is a Telangana High Court is a landmark order? Because T. Tekanu Supreme Court Dr. Chandrachud order is being applied by a division bench of an High Court in an income tax matter. And on the preposition where the issue was ki non-supply of relied upon document, RUD. And the same view, Madras High Court, Falgun Kumarji, Dr. Anita Sumant in one of the other cases, this in the income tax matter, saying that if a revenue is using any material against the SEBI, then they are duty bound to supply it to the SEBI. Now tell me, in how many cases in 148A, they are supplying the complete material to us, sir? They are selectively cherry picking and, sir, half statement, incomplete, some question answer are provided. Is it a supply of material? What is this nonsense? If you are to supply the material, then it is to be complete supply of the material. It cannot be cherry picking and selective supply. In many cases, Kama Shastriji, they don't supply anything. In some cases, they blissfully supply something, but in the name of supplying, they supply some minimum material, which is totally against the concept of fairness and transparency, which Telangana High Court has said in this case, based on Justice Chandrachud order in T. Tekanu. Why I'm saying, Kishorji, all this 148A exercise will become meaning if you don't give me oral hearing, if you don't give me relied upon material, if you don't consider my objections, if you pass what you say mechanical orders and what you pass cryptic orders and just kind of passing the orders, then what is the purpose of 148A then? So 3 points I flag. You have to ask oral hearing. You have to ask relied upon material. Are you noting? Checklist I will just complete. Relied upon material has to be asked in every case from our side. And oral hearing Kama Shastriji has to be asked. And we have to point-wise give our all objections in alternative fashion. Give objection number 1, objection number 2, objection number 3, objection number 4. So I have to try to make a comprehensive reply from my side without having too much expectation that department will do justice with it. Now, there is another point here, Kishorji, before I come up to the another point which I was just coming, and very serious issue. Kama Shastriji, there has been a CBDT guidelines when new law 148 came, dated 1st August 2022. All of you must know. Prasanna ji, CBDT issued a standard operating procedure in this guideline dated 1st August 2022. That how new law 148 will be implemented by the AUs. And there is a point there that assessing officers will supply the assessee proper material, proper oral hearing will be given, and there will be proper sanction in pro forma will be given. Kama Shastriji, tell me in how many cases in your place you have got the copy of sanction? You can unmute yourself, Kama Shastriji. Zero. What are you saying is zero? Zero. Bataiye sir. This is now this sanction is a national secret. आप कहेंगे मिस्टर गोयल आपको क्या हो गया? Why you are saying this word national secret? Prasanna ji, this sanction is meant for the benefit of assessee, or this sanction is a national secret and to be kept permanently secret? See, the culture which has come in the department, Kishore ji, at one side, lawmakers are making such a beautiful law that if reopening is to be done, then it has to be hedged and capped with the condition that after 3 years approval of CCIT, PCCIT, and within 3 years CIT. And guideline says, 1st August 2022 guideline says performa based sanction, where everything has to be properly filled. Now, if this and guidelines say, Kama Shastriji, guidelines dated 1st August 2022 says that sanction has to be supplied with the notice. It is written, Kishorji, in the guidelines that any 148 which is happening in the new law, the copy of the complete sanction, just by writing that sanction has not been taken, it is not fulfillment of CBDT guideline. Guideline says complete sanction should be enclosed with the 148 AD order and 148 notice. Tell me, Kishorji, in how many cases you have got the sanction? You tell. How many cases, sir? So the question which comes here is, what is the reason of this secrecy? Is department trying to hide something? Is these sanctions given in a very total non-application of mind? So department wants to hide something mistake? Or is according to them, it is also a total rough exercise? And why CBDT guidelines says then it should be provided with the notice? You can note one of my argued orders of Delhi High Court. It is one of the unique order we got from the High Court. I was appearing in the High Court, Kama Shastriji. This is a very interesting order. 462 ITR 33 Gudwala and Sons, Delhi High Court. 462 ITR 33. Kishorji, Delhi High Court here said, Justice Shagdar, that non-supply of sanction with the notice would invalidate the entire 148. 462 ITR, page number 33, Gudwala and Sons. And Bombay High Court, now in one of the case, naming, you should all know, this is a landmark order, I'm telling you, Vodafone Idea Limited. What they say is the sanctions which are being given by Commissioner and Chief Commissioner, if the columns in which they have to give it and proper application of mind, it is not done. You know, Kishorji, what is happening? These sanctions which are sometimes, many times given, the proper columns are not written. It is given in non-application of mind and total routine manner. So Bombay High Court has written an order, Prasanna ji, Vodafone Idea Limited, sending this order to CBDT chairman and government's highest FM, etc., that your officers in the country, CCIT, etc., are not giving the approval with proper application of mind. They should be sensitized about their duties. This is not Kapil Goel saying. This is said by Justice K.R. Shriram, Bombay High Court in 12 decisions. One of the decisions is Vodafone case. That mechanical sanction by CCITs should be stopped. It is costing exchequer because High Court says we have to quash the proceedings. Now, Kishorji, if I don't get the sanction, how will I challenge the sanction, Phagun Kumarji? And your Madras High Court has also said in one of the case where they say that if department has to instill confidence in the taxpayer that 148 is not abused, they have to be transparent and at least they have to follow their guidelines, sir. What is this performa of sanction about? And you know, Kishorji, when we go to the income tax department, Kama Shastriji and Phagun Kumarji will correct me. When we go, then they say, no, it's an internal document. It's an internal document. How can it be an internal document? It's a statutory document. Assessee has first right to see it, especially when it is case is being reopened, treating it as an fit case. At what stage I will get the sanction? When I will go away. Therefore, Bombay High Court wants Kishorji that sanctions are not national secret. This is the same Judge K.R. Sriram Saab saying. Income Tax Department should not treat sanction under Section 151 as a national secret. They should give this sanction voluntarily to the taxpayers. But the surprising thing is this, we generally are not getting these sanctions. And where we get Fagun Kumarji, the quality of application of mine in this sanction is missing. That is another point I want to take. Kishorji, are you noting? First, right to have the complete sanction and then application of mine in the sanction.
Sir, sorry to interrupt you. Where 148D order has been passed with the sanction of the appropriate officer, the new law says that again a new sanction is not required under section 148. Can you throw some light on that, sir?
Yes, sir. So these are two different things. You understand. You rightly posed. When the new law came in 2021, they had multiple sanctions at multiple stages, at show stage also, at D order stage also, at notice stage also. So now the current law says you have to have only one sanction when you will issue the final 148 notice and final 148 D order. But I am talking about the duty of the AO to provide the sanction with the 148 notice, A, and B, duty of the sanctioning authority to apply proper mine in the sanction, which should be available in the sanction itself. You know, these performas are filled by somebody else and sanctions are signed by learned officers. This I am saying with responsibility on record. And that is what Bombay High Court Justice K.R. Sriram in 12 decisions have said. A very senior judge, tax judge, has said that please sensitize, and he has forwarded some judgments, I have told the to do CBDT chairman, that income tax officers should be trained how sanction should be given. Because, you know, Fagun Kumarji, what was the reason for Bombay High Court to get anguish? You are filling a column. Now note it down, Kishorji. You can note it down. There is a column in the sanction ki whether case is beyond 3 years or after 3 years, within 3 years. Now, within 3 years, case reopened, sanction of CID, and after 3 years, CCIT. Now, sanction performa says case is being reopened after 3 years, but sanction is given by CIT. And there are cases, Kama Shastriji, where are apparent and glaring errors in amount of income quantified as escaping assessment 0. Can 0 be income escaping assessment and case be treated as a fit case? No, tell me, Raviji, can a sanction given under 148 Fagun Kumarji, where the income escaping assessment quantified in sanction performa is 0, and case is treated Kama Shastriji as a fit case for 148? Third case, facts of, in my sanction letter, facts of Fagun Kumarji are stated, and in Fagun Kumarji sanction, Kapil Goel facts are stated. Who will see, sir? Because this happens because when you give bulk sanctions, wholesale sanctions. And in many sanctions, Kama Shastriji, signage is not there. You now come to Telangana High Court, another beautiful decision where Justice P. Shyam Kosi says any document given by the Income Tax Department, even today, and if it is having no digital signature or physical signature, it is 0. You know what Fagun Kumarji department has invented this argument? Just writing the designation of the officer is okay. Name and designation. But Telangana High Court in this Sai Kumar Rateti versus ITO, 6th November 2023 order. Sai Kumar Rateti versus ITO, Telangana High Court Justice P. Shyam Kosi Saab, where a 148 notice was issued and it was neither digitally signed nor physically signed. It was simply Prasannaji name designation written. Telangana High Court says, Baba, and they cited this section 282 capital A, you can note down, 282A. Telangana High Court dealt with this point. No, even today, if a department is issuing any document, that it has to be either digitally signed or it has to be either physically signed. Now, let me come to very important issue before the time rounds up. So, sorry, sir. Kishorji, what is happening, Kama Shastriji? And this is a very serious issue. I don't know I will be able to take explanation too or not. Now, when the new law 148 is taking place, one angle Justice Krishna Dikshit shown in Vasanti Ramdas Pai that 143 to work cannot be done in 148. Now, Kishorji, there are various cases, Kama Shastriji, I will just give a case study. In the new law, assessee got a 148. Saying that, alleging that assessee purchased a immovable property from a developer and there is a TDS under 194 IEA. So case of buyer was reopened to check the source of the investment, Phalgun Kumarji. Case of buyer is reopened in the new law on the basis of the information that he has purchased some property worth 5-6 crore rupees and revenue wanted to check the source. Although this is a total wrong, in my humble opinion, 148 even today cannot be used for mere verification and roving inquiries. But anyhow, assessee was a complacent man, Kama Shastriji. He cooperated. He was not a agitating man like Kapil Goel. He's chartered accountant, filed the replies, shown the source, but still his 148 AD order was passed in the first round. Then subsequent assessment, Phalgun Kumarji, when faceless assessment was done, he was able to get a Agni Pariksha pass. Faceless assessment was done at written income and faceless assessing officer accepted the explanation of the assessee qua source of investment in the property. You will say, Goel sir, where is the problem now? I'm telling you, sir. Just now, just few days back, Sandeep, my younger brother, said me, Kapil bhai, see, this gentleman whose subject matter has been entirely checked in 148, 44B assessment, his new law, he's now reopened on the same subject matter again with a 148 AD adverse order approval by Chief Commissioner. Kishorji, tell me, is it a joke with the taxpayer? And is it the way the chief commissioners are and officers are accountable to the law? The second reopening, Phalgun Kumarji, which is now done, it is on the same subject matter, same transaction, everything same, amount same, nature of transaction same. And when assessing in the new Kama Shastriji, when this second proceeding started, he gave a reply, his chartered accountant, sir, our first Agni Pariksha was passed. This is the document. This is the assessment. He says, now what do you know? In the D order, what he says, Kishorji, negative D order. In the second D order, he says this assessment order is not written properly in an elaborate manner. So he could not find whether AO and has applied his mind or not. Yes, now, please, all of you, my all friends, I should not miss. Concept of change of opinion will apply in the new law or not. Whether in the new law, assessing officers, Kama Shastriji, are allowed to reopen the cases, even though assessee's assessment has already been completed in 143.3, and there is no fresh tangible material on the record, and it is a pure case of change of opinion. Kishorji, what do you want to say?
Sir, is it a subject matter of 263 or 148?
You are a great intelligent man, sir. I'm saying this is a sharp point. You are right. Even if department wanted to use the remedy, 263 should have been done qua first assessment order. Doing second 148 on the same, this is like digging the same grave which you have already digged. How many times, Baba, you will dig the grave of a man? Sorry. Kama Shastriji, this is the way. One time you dig the thing, you checked everything, then you are satisfied, and then you are satisfied. Satisfied is not an easy thing. Then you are not unsatisfied, then you got the 148 done. Anyhow, Kishorji, I was saying, in the new law, department is hell-bent on this point, and please note it down, this preposition. I want to take it very seriously. In all these 148s, Phalgun Kumarji, you also note it down, which are coming in the new law, especially where 143.3 assessment has been done. Revenue is not appreciating that the concept of change of opinion and previous scrutiny assessment. What they do practically, Kama Shastriji, all these notices which comes under 148A show cause notices, they are based on this mechanical insight portal information is uplifted. And when are not the duty bound to see whenever the information comes to them, Kishorji, has it been already checked or not in 143.3? And what is the status of the previous assessment of assessee? So it means every day, you know, that film 12th Fail, film by this, because this is a great film, 12th Fail, there is a dialogue restart. You know, this 148, I believe, is restart every time, restart with 0. Supposingly, I am Kapil Goel, I file a return for AY 1920, this return is scrutinized, everything is probed. Now 148 is done, believing that there is no history in my case. Is it valid? All of you can note down some citations I am giving in the new law where Bombay High Court specially has come down on this point. That concept of change of opinion, if not read into the new 148 law, then entire law will become arbitrary and unconstitutional. And Bombay High Court specifically has said, Kama Shastriji, that earlier decision of the Supreme Court in Calvinator case in the old law, Calvinator decision, will apply, Kishorji, in the new law. Some citations you can note it down. In the new law, that concept of change of opinion will apply. 459 ITR 524. This is very important, Kishorji. In all these new 148s, the concept of change of opinion is not understood. 459 ITR 524. 459 ITR page number 16. And the leading decision is Bombay High Court Siemens Financial Services. 457 ITR 647 is Siemens Financial Services. 457 ITR 647. Kama Shastriji, this is the leading decision. 457 ITR 647 Siemens Financial Services. Now, Kishorji, this concept is so important. You know, when all these 148s are being given in a second, what you say, pariksha, on same pariksha which you already passed, and you are asked to give a second pariksha, what will be the psychological balance of the assessee mindset? You know, all these cases, Kama Shastriji, after search, when they are invoking a deemed escapement clause, explanation 2, which I am to also take, explanation 2, deemed escapement, Kishorji. They are even not checking what is my ITR, what is my previous history, what is my 143.3, what is the inquiry made in that. Only then you can do Baba 148, na? How can, without conflating the information coming from inside portal, how without correlating it with my ITR and previous assessment, can you do 148 straightway in a parachute manner? Fargun Kumarji, tell me if I'm wrong. All these 148s which are given in the new law, they are directly based on these inside portal information. Without correlating the same to my previous history, whether I am a return filer or not, what is the status of my audited accounts, what is the status of my previous 143.3 regular assessment, and whether what is being now alleged is already checked in that assessment or not. Who will see at what stage, Kama Shastriji, at what stage it will be seen? At the stage of 148A-B, at the stage of 148A-D, at the stage of final assessment, or at no stage? There are 4 stages now. 148A-B stage, show cause notice, 148A-D order stage, final assessment stage, Kishorji, or after that. In my humble opinion, 148 capital A, B stage and D stage is very critical stage, sir. And if it is not being applied, mine, I'm sorry. I have given a checklist, Fagun Kumarji, for today's seminar, a very exhaustive try to a checklist. 12, 15 points are there. In this last point, I will just take up this non-existing facts. What is reopening made on non-existing facts? Kama Shastriji or Fagun Kumarji, can you tell? Pradeep Bhai, can you tell? What is the issue of reopening made on non-existing or wrong facts? This is a very important area. Last day I was preparing a submission for a case in High Court. Kishorji, it is like this, you can all note. And this is one of the very important, objection point, Kama Shastriji, that if reopening under new law in 148A-B, let us say it says that Kapil Goel has sold two properties amounting to rupees 1 crore 30 lakhs. And later on, it is found in the assessment that this allegation in 148A-D order is wrong. Assessee has not sold the property of 1 crore 30 lakh. One property he has purchased and one property he has sold. And the amount is something else. So, there can be hundreds of varieties where reopening can be said to have been made on basis of wrong facts, incorrect facts, erroneous facts, or non-existing facts. You can note all these 4 words. Please note it down. Please note it down. Wrong facts, because then only you will appreciate what I'm submitting. Wrong facts, incorrect facts, erroneous facts, and non-existing facts. Now, Fagun Kumarji, when 148 journey starts, you know, Tirth Yatra starts from, let us say, Kanyakumari, and it goes to Kashmir to another Mata Vaishno Devi. Now, in this income tax 148 journey, Kama Shastriji, 148 generally starts with one set of allegation. By the time 148 final assessment takes place, the basis of allegation gets changed. In how many cases you have practically seen this? I am telling you, it is happening in the new 148 law like anything. The reopening 148A show cause notice tells something, 148A D order tells something, and final assessment order tells something. It is called as change of heart. वो कहता ना हृदय अभी change of heart. Heart is near to Vijayawada or heart is near to Tirupati Balaji. Heart is Kapil Goel's heart. So I'm telling you, their heart gets changes. 148AB, his heart is something. 148A stage and heart gets changed. Kama Shastri ji about the nature of transaction, amount of transaction, and color of transaction. Now I want to submit that very humbly. There is a 12 decision which Bombay High Court has just written in last 2 months, explaining this proposition that if a reopening is made on the basis of the facts which are not correct, admittedly, then entire reopening will fall. Madras High Court is one of the, because Fagun Kumarji, you can note, Madras High Court has also said, very strangely, generally Madras High Court was not saying, but latestly Madras High Court has also applied Delhi High Court decision, saying that if reopening is made on the reasons which are factually non-correct, then entire reopening will be invalid. I have given you 2-3 illustrations. Now, take a case, Ravi Kishorji, if you are not selling a property, you are purchasing a property. It is alleged that you are selling a property. It is not a case of sale, it is a case of purchase or vice versa. Let us say amounts are totally wrong. Year is wrong. Nature of transaction is wrong. There can be multiple errors, Kama Shastriji. You can note in which places you will find the errors. Nature of transaction, you can find the error. Amount of transaction, you can find the error. Quantum of, note it down, Kishorji, this is very important. Nature of transaction, there can be error and there are errors. They are not able to tell what is the nature of transaction. Quantification of income escaping assessment, there is an error. And the year period to which the transaction relates, and the person to which the transaction relates, assessee concerned. These are the 4 points in which you can check specifically whether the reasons are based on correct facts or wrong facts. I have seen, Kama Shastri ji, I was just developing this point last day, and you please correct me if I'm wrong, that if reason says that I have sold transaction of, let us say, X company, but by the time assessment takes place, final assessment of 148, it says that assessee is not the seller of that company shares, assessee is the seller of other company shares. So sorry, my younger son has come. Neha, please take Ivan. He's my special son has come, Raviji, in my room. Ivan has come in my room. Ivan is my special child. So, seminar chal raha hai, isko leke jao. So I was just saying, ki, sir, reopening made on wrong facts. I was just giving this preposition, Kama Shastri ji, that if a particular assessment is reopened on the premise that assessee is a seller of shares of one company which is called as penny stock, but by the time department completes assessment, Kishorji, they say we made an error in spelling the name of the company. This is some other company. In 148 AD order, they tell very limited facts. By the time 147 assessment takes place final, they aggrandize the facts. 2 Bombay High Court orders I found, which says that very uniquely, Kama Shastri, there are not too many decisions, which uniquely says if 148A D order and final assessment order are at variance, then reopening will go on this point. Note it down. If final assessment order and reopening 148A D order, Kama Shastri, is at variance, then reopening will go. I have seen various 147 orders in which are taking. Anyhow, one case of Patna High Court, before I just take small this explanation too. Patna High Court has given Fagun Kumarji one of the favorite decision of this season on 148A. Positive decision, assessee favoring order, and saying that income tax department is misusing the entire 148 and by a judge of South Indian, this judge, Justice Vinod Chandran. Earlier he was in Kerala High Court, now he's a Patna High Court Chief Justice, Justice Vinod Chandran Saab. The name of this case is Narayan Kumar. The name of the Narayan Bhagwan, Narayan Kumar. Why I am saying it is a landmark order, Kishorji, you will appreciate just 2 minutes after, you will appreciate 5 minutes after. Narayan Kumar's case was reopened in the Income Tax Act 148. First, case was reopened prior to the new law. In old law, recording reasons to believe that Mr. Kumar has made some bogus purchases in his concern, proprietary concern. When his case was converted from old law to new law after Supreme Court decision in Ashish Agarwal case, then assessee was given the material allegations notice that this Narayan Kumar Saab has purchased some, goods, etc. from a concern named as Aryan Trading. It's a Kolkata, West Bengal based concern, Aryan Trading. This is written in the judgment. Now, RN trading case, there was an information given to the AO of Narayan Kumar that there is some investigation information that this RN trading company, who is the supplier of goods to Narayan Kumar, is a bogus concern. When his case was reopened, Narayan Kumar, he says that, sir, I have never purchased anything from him. Meaning thereby there was a categorical denial that assessee has not transacted with that. You know the importance, Kamasastriji, the importance of denial is very important. If department is wrongly denying, you're wrongly alleging, then you have to deny. Note it down. Denial in 148A reply is very important, if especially in those cases where allegation is factually wrong. Now take this case progressed. His assessment was also done, Narayan Kumar's, and till the end, Kishorji, this mystery and suspense in this Narayan Kumar's assessment remained whether he has actually purchased the goods from RN trading or not. I am saying to make the thing simple. And Judge Saab, Justice Vinod Chandran, while quashing this 148 in 2024 April, so saying that the entire 148 is fundamentally flawed. Revenue cannot ask assessee to do negative. Number one, note it down. This is the landmark order of April 2024. Speaking by Patna High Court Justice Vinod Chandran, tax judge, that the reopening cannot departments suppose the assessee to prove negative burden. And secondly, this judgment also says if revenue is not fair to the taxpayer in supplying the relied upon material, which is the basis of 148, Kishorji, then entire 148 is wrong. Third, they say as department when now you know there has been hundreds of cases across country when bogus purchase, GST based input reopening is done, bogus purchase. This Patna High Court is a unique decision on bogus purchase. It says if department is to reopen my NSS's case of bogus purchase base, then they should tell what is the quantity, what is the invoice number, what is the, where is the purchase shown in assessee's books and how assessee has claimed it. You can't make it an allegation in air and like a aerial shoot that assessee is found to have made purchase from this tainted entity and which is being recommended by some other investigation wing. So we are reopening the case. That Patna High Court has frowned and deprecated in this landmark order of Narayan Kumar. 3 points. Number one, no negative burden. Number two, relied upon material to be given. Complete relied upon material. Number three, revenue has to show when they are alleging that assessee has made bogus purchases, they have to show that assessee has shown the purchase from the tainted person in his books. As a chartered accountant, you will appreciate. Revenue never tells till the end that assessee has the beneficiary of bogus purchases. They expect assessee will give the stock statement, bank statement, ledger account, everything. Why I will give? This is my normal security assessment going on. You are making a special assessment 148. As Patna High Court has said, Justice Vinod Chandran has said, as Narayan Kumar decision says, revenue has to show that how assessee has made bogus purchases. Then only 148 can be kicked down. I hope this is the right approach, sir. Justice Vinod Chandran's Narayan Kumar order is a perfect, it's a 7-8 page order, but it very classically, succinctly and lucidly discusses the point. I hope it is taken care of by all of you, sir. So now I come just 15 minutes, 10-15 minutes. I will just take this, Kishorji, this explanation 2 part. Now, why this explanation 2 has become a serious headache to various taxpayers? Because explanation 1 is there. Explanation 1 is a general explanation, information suggesting escapement of income. There is a special explanation dealing with special cases of search cases and search-based reopening. Now, Kama Shastriji, explanation 2 to section 148 has 4, cases covered in that, which is part of deemed escapement. Now, this is deemed escapement. One is natural reopening, natural escapement of income. One is deemed escapement. Now, in deemed escapement, Kishorji, explanation 2 says, in simple, I will just try to say as simple as possible. If a search takes place after 1st April 2021, if a search takes place after 1st April 2021 on an assessee, or if a survey takes place after 1st April 2021, that is case number 2. Case number 1 is search takes place after 1st April 2021. Case number 2, survey takes place. Case number 3 and 4 is very important, Kishore Bhai. You know, thousands of cases will be reopened and are being reopened in this third and fourth category. X is searched after 1st April 21. Let us say X is a big corporate bank, financial institution, having dealings with thousands of people, a big corporate. Now in X books, Kama Shastri ji, there are transactions of thousands of other stakeholders. Now this third case and fourth case is of that other person who is not searched, but whose information is detected from the search of. And what is the inference drawn? You know, Kishore, deemed escapement of cases, and now how department is applying it practically. Let us say search takes place 1st April 2022 on X limited company, on whose books they find some regular transactions or some other transactions in the tax books of various people, A, B, C, D, B, A. All their cases of 10 years are reopened under deemed escapement. How many years? 10. And without 148A. Now, this is a very interesting situation. Please note, when you are being under deemed escapement, except survey case, survey will be done under 148A. But for search case, assesses own search and third party search basis, there is no prior 148A required. Direct 148. I repeat, if a case is to be reopened under deemed escapement in the new law, and the case is reopened due to search of the assessee or search on somebody else, then 148A capital A prior exercise is dispensed. There is a proviso to 148A. Now what department is doing, Kishorji, practically, they are directly giving you 148 notice. And how that notice is practically shown, Kapil, Goel, let us say I am the other, that third case and fourth case, Kapil, Goel, we have information in our possession on base of search on Ramlal. Now nothing else. There is a simple line written, Kama Shastri ji, Kapil Goel, your case is directly reopened under deemed escapement. Even deemed escapement is not written. They say your case, we have information on basis of search on Mr. X. Nothing, no document attached, no approval attached, no quantification there, nothing. Is it okay? I want to just give 4 points to my viewers on explanation 2. First is very important, is in which clause of explanation 2 my case is being reopened, Kishorji. You can note, explanation 2 has 4 different clauses. Revenue, while issuing notice, cannot issue me vague and omnibus notice. They have to pinpoint, Kama Shastri ji, in which pigeonhole and case of explanation 2 my case falls. If it is not pointed, in my humble opinion, the entire 148 notice is invalid. Second point I want to say is sanction. Here also, Kishorji, in deemed escapement, law does not say sanction is not required. Law says sanction is required. And they are taking sanctions, but they are not properly giving it to the assessee. Or rather, what is happening is, those sanctions, when the assessee has given it to me in search cases and these third party search cases, the quantum of income escaping assessment, Kama Shastri ji, is written 0. Can there be income escaping assessment cases, even though deemed escapement, without in 0 assessment? I don't understand what is this. Sanction performa says, Kishorji, the income amount of quantum of income escaping assessment 0. And case is reopened under explanation 2 to 148. Is it okay? In my opinion, the sanction and amount of income quantified must be there. Without proper income being escaping assessment, I believe in deemed escapement also the reopening cannot take place, sir. Third point is section 149 subsection 1 conditions. First I told relevant clause. Second I told sanction. Third is 149 subsection 1 condition. Now Kishorji, let us say a case is reopened under the deemed escapement after 3 years. Whether 50 lakh criteria will apply or not year wise? They are not applying. Rather, the mystery is this, Kama Shastri ji, in the new 148 law, the revenue's understanding is this: when we are reopening under deemed escapement, we are not supposed to tell anything. We can keep everything surreptitious under the carpet. Let assessee guess why his case is reopened. Let assessee keep guessing. My submission, Kishorji, is this: in the new law of 148 explanation 2 deemed escapement, the department is supposed to enclose with the notice. Please note it down. What they are supposed to enclose: sanction. Second, the material in their possession, which they have found during the course of search of other person, so that I can file a proper objection. Now, See, in my case of deemed escapement, no 148A has done. So that assessee is allowed, Shastriji, to now take GK and drive shaft after 148 notice stage. I repeat, Kishorji, in deemed escapement case, department is not doing 148A. Department is straightway giving us 148 notice. So my submission is this: we should be supplied all the relevant material along with the notice itself, so that assessee can now take the GK and drive shaft cycle from notice stage. So I believe you have noted relevant clause has to be assessed to be pointed out. Sanction has to be properly there. Relevant incriminating material. And my opinion, the test of incriminating material, Shastriji, I say with responsibility, the test of incriminating material which was there in 153A has to be read into the new law to make it constitutionally valid. This is my respectful submission. Department cannot say in the garb of deemed escapement, without having any tangible incriminating material, they can arbitrarily reopen my case, Fagun Kumarji, which they are doing, and that too of 10 years. And that too when many years are assessed under 143.3. So somebody asked me, like my Pradeep Bhai, please open your mic and video. Pradeep ji was therefore, he asked me a query, Kishore ji, a very important query. In Calcutta, he's one of the client has been issued in the explanation to 4-5 notices, 4-5 year notices. And those notices are very, what you say, vague. Nothing tells on what basis they have given, no sanction letter, etc. No incriminating material, no 50 lakh condition, Shastriji, straight notices comes. Now I told him two things. Baba, first you should ask them, please supply me the relevant sanction and the material gathered against me in the search. And then you should file GK and drive shaft proper objection, preliminary objection. You all know you can file in deemed escapement also the proper objection as per GK and drive shaft. And third, if the department is not accepting our objection, which as expected, then you can go in writ petition. So this deemed escapement, Fagun Kumarji, this normal escapement has not given us so much of work. See this deemed escapement, how much work will be generated. Just try to imagine there is a corporate having thousands, lakhs of transactions. It is being searched after 1st April 21, and the department arbitrarily reopening the case of third parties in this deemed escapement. How many people case will be reopened, sir? I'm saying not will be reopened. Already in 2024, from all places in the country, I am told that Goel sahab, this deemed escapement clause has been used like in a very, very mad manner. A case, Shastriji, chartered accountant, senior like you from this Patiala, he asked my professional opinion, Mr. Goel, this is a deemed escapement case, and 3 years notice is given, and quantum of income escaping for 3 years in which notice is given is 0, 0, 0. Is it valid? And then he asked me very interesting question, Kishorji, a typical CA question, ki Goel sahab, in this 0, 0 wala case, what is the chance that our subsequent assessment will be done at 0? Without any addition. मैंने कहा only Banke Bihari and Venkateshwar God can answer it. Kapil Goel can never answer this kind of question, sir. This is a see na, reopen done under the new law, deemed escapement, quantum of income escaping assessment 0, 3 years 0, 0. Now, when the assessment will take place, Kama Shastriji, our gut feeling says department will ask everything, general questionnaire will be given, everything will be asked. And what will be the shape of assessment, Fagun Kumarji? So this is the area where, Kishorji, this explanation to section 148 deemed escapement and versus subsequent assessment, this is going to be a definitely testing point for various taxpayers in the country, sir. I have given 4 points. Sanction letter you take, relevant clause you ask, relevant material you take, file a proper objection to the authority who has given a deemed escapement notice to you, and insist to the revenue authorities, they restrict to those years in deemed escapement for which they are in possession of some material. Not 0 wala case, at least. And at least those cases 149 subsection 1, 50 lakh criteria is not fulfilled, should be dropped. So I believe I have tried to cover, sir, within given. Now we can take the queries answer, Kishorji, of all the participants. And I'm thankful to all my viewers. They have beared me, jailing me from last 2 hours. I don't know how much my confabulations are found in order, but I tried my level best that to cover up the subject in comprehensive sense, I have given 3 pointers, 3 things to branch. One is my checklist. Second is this questions on this 148 explanation 2. And third is the tabular comparison of new explanation 2 versus 153A and 153C. With this,
Yeah.
I thank all of you, and now floor can be open for question answer, sir.
Yes, sir. Definitely we will share that. And also I should remind our viewers that this is a recorded one. It will be available on YouTube for any number of place afterwards. Sir, you have covered actually what are all the intricacies which are involved in section 148. Day to day, many of us are facing, if not all, at least some of the issues which have been done. But we practicing chartered accountants and consultants from areas like Vijayawada, we are under a dilemma that we have pointed out a question of law whether that 148 can be opened even though 50 lakhs has not been crossed, or there is a wrong information or incorrect information based upon which the case has been 148A has been issued. We got a unfavorable, we give, sir, 148A, previously I was quoting it as a naam ke vaste. I will tell you one.
I'm listening, sir. I'm listening. My full mind is with you.
I will tell you one example, sir. A non-resident purchased a property, say
AY, assessment year?
in assessment year 2021. He purchased or 1819.
Okay.
Year I'm not sure.
Hmm.
But I will tell you on what basis 148D has been 148AD has been passed. Actually, he is a non-resident for many years. He is earning a good amount of money outside India. He has remitted to India, and since the property is somewhat a premium property, some money he has adjusted it from his father and mother.
But
Now
he has
got-
purchased the property.
Yes, he has purchased the property. The exact amount of source of income, etc., was there. While replying to 148A notice, all the bank accounts of the parents of the SSC and the source, the document, and also the purchase document will contain the dates on which and the amounts and the check numbers by which the amount has been transferred. Everything has been explained to the fullest extent, and he has no other income. 148D has been passed in the pretext that the SSC did not give the information as to whether, and I'm sorry to state that he did not establish his relationship
You need
with
not feel sorry, sir. You need not feel
father.
sorry. Please. Be blunt. Be blunt. Courts are saying, please.
Saying that A is the SSC, you say that B is the father of A. She is the mother of A who has who has given some money from their known sources. You have given the bank statement also. But the SSC in his explanation to 148A notice did not give the proof that B and C are his parents.
This is where that is, you are absolutely right. Now your dilemma is what?
Sir, actually, during the course of the proceedings, if you would have asked that information, prove that these two are the parents of that person, I would have definitely given the Indian
But
passport.
that is not the subject matter of show cause notice under 148AB.
148A show cause was given to prove the he has not furnished the return of income because he has no source of income in India.
But you told the
He has
sources
purchased.
now the source of source thing, has he given you proper show cause notice under 148AB?
No.
So it is, see, what I'm telling you, I understand. There are 2 points, sir. You note it down, Kishore bhai. You apply 154 to them. That you should recall your 148A order because you have never given me 148AB. Qua this thing. Law says the sequence of 148A is very sacrosanct. You can't say that in the final order, when you will pass a fit order, you will say the allegation of income escaping assessment is at variance with my 148AB show cause. And secondly, I say it like this. The starting point of 148AB was that Kapil Goel is a non-filer and he has invested into immovable property. To check my source of investment, you gave me 148AB. Now I said I took Fagun Kumar and Kama Sastri ji gave me unsecured loan and I purchased the property from there. It is like that. Now, in the final order, you say that Kapil, this Kama Sastri ji and Fagun Kumar's credit worthiness is not properly established. So this is 140. Arey Baba, have you given me show cause on that? Have
No.
you assumed jurisdiction on that? Is the inside portal information on that? Is the risk management information on that?
Sir, now
So-
in these type of cases, sorry to interrupt, my query is, what the SSC has to do, sir? He has to go to the writ petition route, or he has to go to the
A very intelligent question, Kishore bhai. You can note three or four rastas are there. This is a very important question which you asked. I will just highlight you 3 or 4 routes. One option is writ petition. Second option is you go to subsequent assessment and try to show to the assessing officer that the wisdom prevails on FAO. And third is when you will get an adverse order in 148 assessment, final assessment, then you go in appeal. And fourth is rectification of 148AD order, which is very rare. Are you noting these 4 options? Fourth one is very interesting to explore. I say, if your case under 148AD is decided in violation of the procedure of 148A, nothing in the, kindly read 154. Where does it say that rectification cannot be applied by the assessee against 148AD order? You may say, ki, Kapil ji, that 148AD order rectification, nobody will entertain and correct it when already approval of is taken. But your case from subsequent litigation point of view will become stronger if you will file 154. Even though department does not appreciate that. So one call you can all easily do is you can file a proper rectification application qua 148AD order that it is in violation of process of 148 and you have not been given proper show cause notice under 148AD. Second aspect which you ask, Kapil ji, whether we should go in a writ petition or we should go cooperate in the subsequent assessment. That is writ petition, Kishore bhai, is a situation where it's a discretionary remedy. I have already told you many judges in the country are not happily entertaining it.
alternate.
As I said, was Allahabad High Court and MP High Court, Deepak Kumar Yadav and Amrit Holmes case. So I don't know how should I say it. I say it like this humbly, chastefully, that you have to check from the concerned counsel of that High Court where the judge, who judge will hear you. Depending on that, you should answer this question. Are you getting my point?
Yes, sir. Yes, sir.
Supposingly Lord Ram will see, it is like this, Lord Ram will hear my petition, Lord Krishna will hear my petition, or Mataji will, Hanumanji will hear my petition. Depending on that, you have to take a call.
Yes, sir. And also for that rectification part also, already 148 will be issued and 30 days or 90 days as the case may be, that time will be running out before this.
But filing of, you take it from me, Kishorji, please pause here. Filing of return is a clerical thing. It will not confer jurisdiction on the AO. Please don't mistake, please all of you. Even if you file 148 return under protest at the same amount which you filed earlier or a nil income, then filing of return of income under 148 will not should not be treated as a waiver of your jurisdictional objection. Are you getting my point? This is a straight answer. This is held by courts. Because ultimately jurisdictional issue, even you can take it first time before the CIT appeal and ITD when you will fight in the assessment. You know, Telangana High Court is the only High Court in the country which has given this landmark decision on base of which 1,148s have been quashed in your land, in your state, sir, Telangana state, by Justice P. Shyam Koshi Saab, this Kanakala Reddy. Kanakala Reddy is a judgment of Telangana High Court of 14 September 2023. You can note, Kanakala Reddy. It says that in the new 148 law, if any valid notice has to be issued, it has to be issued in faceless mode. It can't be issued by jurisdictional officer. Where all these 148s which are being done in from 2022 when this notification came, you know, Kishorji, all these are done by JAO. And Telangana High Court, your jurisdictional High Court, I believe, says Kanakala Reddy, where 1,148 are quashed. Daily I see in Telangana High Court website, 10 matters are quashed. So you are in a still better position. Sorry, this position, although various high courts, Delhi also, we have got interim stay, but final order is given on section 151 capital A. This is section 151A, faceless mode of income escaping assessment. You know, all these 148 notice in the new law, even today from 2022 past, all these notice Fagun Kumarji are issued by JAO, judicial officer. Telangana High Court Kenakala Reddy says it should be by FAO. In automated faceless, that is section 151 and CBDT notification dated 29th March 2022. You can note this notification. CBDT notification dated 29th March 2022 under section 151A, which is being applied by Honorable Telangana High Court in Kenakala Reddy. And Kenakala Reddy Kama Shastriji, I could not find, it is even not today, I do not see any SLP against that in the Supreme Court. So Kishorji, you from your place, I can say you are blissful situation that Telangana High Court has taken such an important decision. Section 151A says in the new 148 law, you have to give 148 notice in faceless mode, not JAO mode. So that can also be explored and navigated. You take this objection in subsequent assessment. See, not issuing the notice in the new law today in faceless mode and issuing in the JAO mode, you can always keep this Kenakala Reddy decision on your side. That is my humble suggestion, sir. Good you ask this point, sir. And you can also see, if you don't want to burden the assessee with economic cost of writ petition, you can save his cost and request him to keep them reserved for subsequent litigation in against assessment order. That is how I can answer it.
Sir, what is happening in some high courts, whether I can say this or not, in Andhra Pradesh High Court recently, the persons, the consultants, the advocates who filed the writ petition are saying that the judges are in favor of that the assessee should go, because he has an alternative remedy. He should not come here. He should go through that assessment procedure.
That is what I was submitting. That somewhere we need. That's why all this decision of Odisha High Court, Biju Janata Dal, Bombay High Court, Karan Maheshwari, and this Delhi High Court, and all these High Courts I told, Madras High Court, IDFC Limited, and this Matthew Cherian. That this, see, after new law, I have no alternate remedies, sir. This is wrong. Neither 148A order as such is appealable under section 246A. And secondly, that's what Calcutta, this judge of Madras High Court, earlier judge of Justice Madras High Court, this Justice Sivanganam Saab, now Calcutta High Court Chief Justice, he has said in many cases that 148A order is not appealable order, Kishore Bhai. So there is no alternate remedy as such. So that's why I asked this very pertinent question to all my viewers, including you, whether in the new law I have gone above GK and drive shaft or we have gone below GK and drive shaft. And when GK and drive shaft objection disposal order can be challenged in writ petition, why not 148A order then? I hope I am answering what you are saying. But that's the right practical point. I also take it in my submissions that various High Court judges, with due respect, are not able to completely understand the nuance of this new scheme, especially 148A order nature. They believe that in the subsequent assessment, assessing FAO or the concerned officer can totally review the entire 148A. I hope that understanding has to be rationalized.
Sir, one or two issues we have in chat box. Some are asking about the citations of some of the case laws which have.
I'm just telling, kindly note the citation of this T. Tikanu first.
T. Tikanu. Yes, sir. Someone
T. Tikanu's complete citation. I am just, can I put in chat box?
Yes, sir.
Will
Yes,
it be okay?
Yes, sir. No issue.
But I'm not able to see that it will go to everybody. How can I put it, send chat to everybody?
In the bottom of that chat box, 2 is there. There you can, in the drop down list, you can select as all.
Please kindly forward. Just I am telling to you, sir, this kindly note T. Tikanu citation, just so that time. Kindly see this T. Tikanu citation.
Okay.
I'm just putting in chat box. You forward it.
Yes, sir.
See this came, sir.
I have not received that.
Meeting group chat.
Meeting group chat in the drop down. Yeah, Tikanu versus Securities and Exchange Board.
Kindly note the citation I'm giving, sir.
Yes.
This has come?
Yes.
2022 8 SCC 162. Has it come,
Yes,
sir?
Yes.
Now please note the Bijinder Singh citation. Because I don't want to keep anything outstanding on my part. Sorry. Just a moment, sir. Vijender Singh is. I'm just putting in the side chat, this chat box, sir. CCIT
Vijender Singh.
6852/22 order dated
4th of January 24, sir.
Has it come, sir?
Vijender Singh versus PCCIT. In
This
petition.
is not reported. This is writ petition number, and this is by Rajasthan High Court. I have given WP number 6852/2022, order dated 4 January 2024 by Rajasthan High Court.
Yes, sir. Kamasastri sir is asking, the department is quoting Jitson's case of Kolkata High Court against Kanakala Ravindra Reddy case.
No, sir. After that, Girdhar Gopal Dalmia Justice Sivanganam's order, you can please have Kamasastri ji. Girdhar, see, firstly, judicial high court, when two views are possible and your particular high court is not there, view which is favorable to you, you should be adopted. You know better than anybody else. Second thing, sir, is with due respect, that even Justice Sivanganam Saab Division Bench, Vijender Singh case is, to my mind, I don't see the citation. I just got the unreported. You know my nature. I generally go by unreported decisions. So I was submitting to you, Kamasastri, Girdhar Gopal Dalmia, you can have Justice Sivanganam's division bench order. Rather, he has given stay, and various writ petition in Calcutta High Court have been admitted on based on Kanakala Reddy. So Calcutta High Court is also friendly. I don't see any High Court negative order like that. Even Allahabad High Court latestly has given stay on basis of this, and I have got half dozen stay by Justice Rajiv Sikdar in Delhi High Court. So that is a point, sir.
Sir, one query from CA Sarvanan.
Kamasastri ji, am I clear? You got my point, sir? Okay. Yes, sir. Saravanan sir, kya kehna, sir? Please.
We want to know your comments on 135A, where no 148A-B notice is issued or not required to be issued.
Sir, this gentleman who is saying SLP has been filed against Kanakala Reddy, to my understanding, I could not find. There are two tax benches in the Supreme Court, B.V. Nagarathna Madam and Justice Obey Oka. I could not find, I don't know, or whether before Justice Dr. Chandrachud also, because three courts I tracked, Dr. D.Y. Chandrachud court, this Justice Oka court and Justice B.V. Nagarathna court. I don't know in which court you are talking about. Anyhow, this... So that's a different matter. If it's not listed or registered, then I can't tell if it is in the cooking store or some cooking wave. See, September 2023 order, I am in April 2024. I don't know, what SLP rules, Supreme Court says how many days the SLP has to be filed. And delay, the Justice Nagarathna, ma'am, tax bench is very strict. If you follow Justice Nagarathna court, you see she's very strict on admitting the SLPs of revenue. She's daily dismissing SLPs where delay of 200 and 300 days is there. Yes, sir.
Sir, Falgun sir, I respect Kapil sir's time.
No, Sarvanan sir is asking, sir, your comments on what? See, this is very interesting.
No. Falgun sir, I am requesting to give his comments on the session. That's what I'm asking.
Yes, he can give. Just I will take this query, just Saravanan sir's query with your kind permission. That, sir, your comments on 135A where no one... See, again, Saravanan sir, you note in my point. All these cases where department is preempting 148A and saying that section 135A, some verification report has come. Whether that verification report is made available to you, A. B, and whether that verification report which is made as basis to initiate direct 148 without 148A has ingredients of income escaping assessment. Because you should, Kishorji, all of you know that in all these cases where this Saravanan sir is saying it's very important. Some chartered accountant came to me latestly in this last week, a senior chartered accountant. He asked me, Goel sir, this 135A, there is some verification process done by department, section 135A. They do not do 148A, they are directly giving 148. Now I asked whether you are given this verification report. He said, no, Goel sir, we are not given. So first thing is this, they should supply me that report. Secondly, then the most important crucial question, Kishore Bhai, that sanction letter and how they infer that it is suggesting income escaping assessment, because in 135A case, it still should qualify as information suggesting escapement of income. Read first proviso to 148 section. It says that no 148 notice can be issued unless there is a proper sanction and unless there is information suggesting escapement of income. So 135A can be made as actionable basis if there are valid ingredients of income escaping assessment. Just now what was the case in that case? Just to make roving inquiries and fishing inquiries and on wrong facts. That verification report was saying wrong facts. So three things: whether verification report is made available to you with the 148 notice, A. Second, whether it has information suggesting income escaping assessment criteria fulfilled or not, B. And third, it is based on correct facts or not. I hope, Kishorji, you see, all these clauses, I don't know. On lighter side, Prasannaji, I say, when 148 new law was made, now my good friends will know, Kama Shastriji, when 148 new law was made, explanation one size and explanation one size was 2 clauses. Later on, it became from 2 to 5 in explanation 1. There were 2 clauses, audit objection and information suggesting. Later on, these 3 are added. That 135, etc. Now somebody asked me, Goel sab, this increment will this can be the further can be clauses can be added in the future time. Again, that is a futuristic question. Somebody wiser like Kama Shastriji or Prasannaji or Phagun Kumarji can answer it. I can't answer this. But I am telling you, all these clauses added year by year and revenue become wiser year by year is going to generate more and more 148 cases against that idea which was in the new law.
Falgun sir.
Sir, just my query is whether there is any bar on department in providing the adjournment to SCN as they are not considering. Sir, there is no bar, Sachuji. Rather the law is very liberal. Extension has to be provided liberally. Principle of natural justice are codified. You read 148A heading, providing opportunity to the assessee is the marginal note of section 148. What is the opportunity word, sir? People who are, now see, my good friend, somebody asked me this is that with reference to Kanakala Reddy, even if Telangana High Court quashed all consequential orders, but stopping ITO revenue to reopen. See, somebody should tell them that if they initiate second inning, third inning, fourth inning, there is a Parshuram portrait decision of Supreme Court. Justice HR Khanna, 106 ITR, page number 1. It's not like a battle for all infinity. If department makes one wrong error, then for all future ages and infinity, they can keep on issuing 148 after 148. Guy Carpenter is a decision of Madras High Court authored by Justice Sivanganam and Dr. Vineet Kothari. That second reopening is not possible. You need read Madras High Court Guy Carpenter authored by Dr. Vineet Kothari and Justice Sivanganam. So this business of department doing 148 first round, 148 second round, 148 third round, 148 fourth round, for them this is an infinity business. But for Supreme Court, already there is a law laid down by Justice HR Khanna in Parshuram Potri, last paragraph, that can the revenue be taken benefit of their own remissness in 106 ITR volume, page number 1. Somebody should enlighten their attention to that. It means that, Kishorji, you make first red light jump, you make first wrong thing, then you make second wrong thing, then you make continuous wrong things, because you will be awarded for your wrong things. And nothing will stop you because we are in an uncontrolled scenario. No High Court. It looks like this, that this subject is such a naive subject that our High Court judges and our Supreme Court my lords are having nothing they have said. You know, Dr. Vineet Kothari and Justice Sivanganam came down very heavily when second reopening was done on the same subject matter when first reopening was quashed. People who have some sense to the law and rule of law will appreciate what importance that you have to have some finality. That is what Justice Khanna said in Parshuram Portraits, that there should be some finality to the tax litigation.
Yes, Falgun sir, I wonder what you were saying previously with regard to Kapil sir. He quotes the issue, he quotes the SSC name, he quotes the citation including page number, and he quotes the judge name also. And if there are more than one judge, he quotes all the judges' names. Sir, how is this possible, sir?
Sir, iska reason hai, so people do not take my good friends that Kapil Goel is making bluff. Somebody who is Kama Shastriji is vouching me, hardly or some other friend, he can, if it is hard vouching or hard surveillance, then I should not be on the wrong side anywhere.
No. 100% we are. I for one strongly believe that it's 100% that you never quote a wrong thing. So this is extraordinary stuff, and we are very fortunate to have someone like you on our channel. So
This is all blessing of Ma Saraswati and all of you, Prasannaji and Prasannaji, Kama Shastriji, my good well wishers like you, all of you, sir.
after having a good feast of knowledge, nothing to add, because already the amount of information, the elevation of the spirits, an average CA normally is shy of fighting. An average CA, I am sorry to say that
Right, sir, right,
litigation.
sir.
So, but after hearing Kapil Goel ji at least once, everyone can increase his spirits. To do the justice, you have to fight. Otherwise, say if you simply surrender, justice cannot come to your doorstep. You have to fight to get the justice. So that's how he has quoted number of decisions, and especially on this 148, because tomorrow, day after tomorrow, the first appeal and the second appeal tribunal, the foundation is the assessment, especially this reopenings. So the department's view in that section 135, in 2021, they introduced this e-verification scheme, not the written filed e-verification. They want the portal information to be verified, compliance portal, and then, so in your portal, you should go to the compliance and then e-verify. Because you are not verified, you have not contradicted, I take it as income escaped, so I issue 148 notice. Is it the way? Have they applied logically? So all these things Kapil Goel ji has elaborately given. So many issues are there, right from the technicality of issuing the notice, then providing the, on the basis of principles of justice, say the information available with the department, has it provided, has it given a fair opportunity for the SSC to deny and then defend. So all these things, just like a downpour of say rain, Kapil Goel ji has quoted so many decisions and authoritatively said, you defend yourself. Now it is the law. So he has say all the participants, I am sure, have got a lot of benefit out of his this thing. I am thankful, and not only on behalf of the Vijayawada branch and all the participants behalf also, I say for the good spirits he is having to share the knowledge. Whenever you invite, say he is willingly sharing this much valuable information. He has got no time. Various high courts he is appearing. In spite of it, he spared his time. I think his book on 148 is there, no, sir? Your book is there. You wrote and
Yes, so
please.
that's a small written thing. I that keep on changing, because now what is happening, Fakun Kumar ji, so much of jurisprudence is coming. You know, every week 148, there is a different sense of understanding now.
I think
And so many high court judges, like Shivanganam Saab saying one thing. This judge, you know, we have to also keep a track judge-wise. Justice Shriram saying what? Justice Yashwant Verma, Delhi High Court saying what? Justice B.B. Nagratna saying in Supreme Court what? Justice Dr. D.Y. Chandra saying what? Justice Oka saying what?
Yes.
Yes.
It is in e-book also is the taxman they have released, not only physical book, I think e-book also they have released, sir. So I'm sure this will be most useful to all the participants. I thank you for giving me this opportunity also. I thank the
Yes.
Vijayawada.
I also recognize the past chairperson J. Srinivasrao of Guntur branch. He was in the session also. Sir Prasanna sir, though you are in a hectic work of the institute work, you were at Noida office. All the way you traveled to the place of your stay. All the way I was looking at your what you call file in the Zoom. All the way you were concentrating on what Kapil sir was saying. So
Yes.
I appreciate in back of your mind there are so many things to deal with, but your enthusiasm to update yourself as far
Yes.
as 148 is concerned, it is appreciable. A word from you, sir.
Yeah. That was a great dinner. It's a very great session. In fact, I want to attend from 6 o'clock to 6:15 only. 6:15 hours, I had some other meeting, some people are waiting. In spite of that, within that 5 minutes, so much attraction was there. So somehow I tackled them and continued here. Very nicely you said, but today's value addition is like CA Falguni Kumar, Dr. Falguni Kumar was telling. See, we the chartered accountants who don't have the spirit of fighting. Fighting in sense, something is there. Let us take it to the higher forums, get some justice done, buy some justice. We don't have that. ఏదో ఒకటి ఏదో అటు సర్దుకొని పోతాం ఏదో మంచిగా వెళ్ళిపోతాం సో దట్ ఇస్ ద వే వి గో దట్ ఇస్ ద మెంటాలిటీ ఆఫ్ చార్టర్డ్ అకౌంటెంట్ సో ఐ థింక్ ది డేస్ ఆర్ కమ్ in the faceless regime, so we need to really fight. The interpersonal relationship is not there, so we have to do it. So that we also has covered very nicely well. So thank you very much, Kapil. So fantastic. Great
I'm
session.
blessed, sir. I'm blessed.
Sir, Kapil sir, I should also tell you with the words of Falgun sir and Prasanna sir, now some practicing chartered accountants are surrendering their COPs. They are pursuing this LLB or something, and they are into litigation practice. Of late, I
Yes,
have
sir.
heard
Yes,
some
yes, yes, yes.
two
The
or
reason,
three
you know,
people
there
doing
is a
that.
very important reason because you can go in high courts and you can file writ petitions and you can bring the officer to the books, law books. If he's not doing, 90% cases or majority of cases I have seen revenue executive to be on the wrong side. Especially when I have a different way to sometimes see, I don't know whether I have spoken like that here or not. Constitutional way of understanding the things. Article 14, Article 19, Article 21, Article 265, all these constitutional important articles, if you keep in mind and then prepare your presentation, then it will be a totally different presentation, sir.
Right.
And when we appear in Supreme Court and High Courts, our good great judges like P.S. Narasimhan, these great judges, Dr. Chandrachud and all these great judges, legal scholars, what they say, if somebody has to make a legally good submission or presentation, then you have to always keep constitution on your side.
Yes.
I don't know how much time how much we factor Constitution of India into our pleadings or what you say submissions or your arguments. My favorite is Article 14 because that says that if any action of state has to pass the test of the Constitution, then it has to be non-arbitrary. And 9% of state action is arbitrary because it is with non-application of mind. Non-application of mind is facet of arbitrariness. I can cite 100 of decisions on Supreme Court on this. That Article 14 is non-arbitrary. Article 14 contains equality. But Kishorji, you can note it down. It's a very interesting one-liner. Article 14 of Constitution of India gives you protection on equality. Equality means the state action should be personally non-arbitrary. Non-arbitrary means it should be with application of mind. If it is without application of mind and non-application of mind, then it is arbitrary and it is violative of Article 14 of Constitution of India. There is 1 dozen Supreme Court 5-judge bench decision on this. You go to Article 14 commentary by anywhere from start. Article 14, you will find various Supreme Court orders saying that any government action, any state action, any executive action, if it is arbitrary and without application of mind, then it is violative of Article 14. I always humbly suggest to my seniors also that when you file appeal in income tax, we can always plead that there is you can always take a ground that action of the income tax officer is vitiated due to arbitrariness and with non-application of mind. Take it from me. And you will find the colors of it. Some sensible judge comes to it, it will drink the things. This is not musical, Article 14, etc. are not dolls.
Yes, with that note, CA Srinivas, you have something to say? Srinivas? You are not audible, I think. You have to unmute yourself.
You have to unmute, sir. You are yes.
Thank you very much, sir. Thank you very much, Kishorji and Prasanna Garu and Kapil Goel. Sir, for the practicing chartered accountants who are on litigation side, you just go through all the videos of Kapil ji. You will be in a position to gain the case, win the case. Actually, sir, I have been listening to your videos long back, sir. I'm just quoting your case laws also. I'm your fan of you, sir.
Sir, आपकी वजह से हम जिंदा हैं, sir.
A sort of Ekalavya Shishya to you, and he is winning cases.
Yes, yes, sir.
The citations of which you are the.
हमारा तो अभी हमारा कोई फैन कहाँ है? अभी आप लोगों का वजह से ही हमारा चल रहा है, सर, जिंदगी.
No, sir, I came to know that your date of birth is 82 December, no, sir?
Yes, yes, 29 December is my birthday.
Yes, sir, you are so much younger than more than 80% of the people appearing in this conference. Sir.
Yes,
yes,
yes.
sir.
So with that note,
God bless you, sir.
Thank you very much.
Thank you, sir.
And on the I wish that goddess.
प्रसन्ना जी, एक दिन आपको ये प्रोग्राम भी कराना है कि how to use in Constitution of India in day-to-day tax practice.
Okay, yes, we'll have it. We'll have it very soon. All India will have it.
How to use Constitution of India by chartered accountants in day-to-day practice.
Yes, 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 yes.
God
Hello?
is.
This is an unsolicited suggestion. Sorry, apologies.
No,
No,
no. It is solicited from our hearts. We could not spell out. That's all.
And Prasanna ji will say that that program is organized by or hosted by Vijayawada branch.
Okay, done. Whether hosted by or not, you will appear there. You will moderate the session. Hosting, I have to talk to the respective committee.
Sir, on behalf of all of us, I wish that Goddess Kanakadurga will shower all her blessings to you and your family. And the next time you come to Vijayawada, you will have a very good darshan of Mataji and the blessings to the fullest extent. So thank you, Prasanna ji. Thank you, Falgun Garu, and all the participants who have joined. On behalf of Managing Committee of Vijayawada Branch, I thank you all of you for sparing your time, and especially thank our session speaker who has enlightened us. So friends, tomorrow
May Lord Ram and Lord Krishna bless Banke Bihari. I generally say, may Thakurji and Banke Bihari bless all of us, sir.
and tomorrow is Falgun sir sessions. Somehow your SSC has got the assessment order under section 148 after 148 8D. So what next? What next is tomorrow at 6 p.m. See
Great.
you. Thank you.
The saga continues.
That's all.
Yes.
Thank you.
Thank you.
Sitaram, sir. Ram, Sitaram.
Thank you, Falgun Garu.
Thank you, sir.
Kapil Garu. Thank you.
Thank you. Bye.